You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court. Please be seated.
Good morning and welcome to the Florida Supreme Court. First case on our docket this morning is Coleman versus State of Florida.
Please the court, counsel. For the record, my name is Martin Mlan, and I'm here today on behalf of Mr. Coleman in the appeal of the denial of 3850 relief and his that happens every time, and his petition for writ of habeas corpus. It's my intention today to address the penalty phase ineffectiveness claim first. That's argument one. A number of issues would be mooted if I prevail on that. I don't mean to denigrate them. I think I should win on those as well, but time doesn't permit, obviously, everything. I also, to the extent I can, want to address the appellate ineffectiveness claim in the state habeas petition, which concerns guilt phase issues. First, as to the penalty phase ineffective assistance to counsel claim, after the briefing in this case, the legal landscape on ineffective assistance to counsel was changed dramatically by Porter v. McCullum. And I don't know that that's gotten much attention, and I just want to explain. In Porter, the U.S. Supreme Court found this court had been unreasonable. And what was unreasonable was giving deference to the trial court's credibility findings as to the mitigation offered in support of the prejudice prong. And in essence, actually, if you go back to Porter v. State, the basis for this court's opinion was Stevens v. State, and this court's statement that we do de novo review, but we defer to the factual findings and the credibility findings of the circuit court. And the U.S. Supreme Court in Porter v. McCullum made it very clear that's an improper construction of Strickland. And so Porter is to Strickland what Hitchcock was to Lockett. And Porter makes it very clear that that's the standard that has been applied.
So what are you really saying here, that we're not supposed to give deference to the trial court's factual findings? Tell us exactly what it is you think Porter says that changes what we should be doing.
In Porter, specifically, the Florida Supreme Court did not consider or unreasonably discounted the mitigation evidence adduced in the post-conviction hearing. It also says, while the state's experts identified perceived problems with the test the doctor used and the conclusions that he drew from them, it was not reasonable to discount entirely the effect that his testimony might have had on the jury or the sentencing judge. And so this court had said, since the judge who presided at the hearing had credited the state's experts, we're not going to include Dr. D's testimony in our evaluation of the prejudice problem. And so...
Well, just so because we could spend a whole oral argument on Porter. In this case, I take it as your argument is that, I mean, in Wiggins and all the other cases, that this defense lawyer prepared for the guilt phase and did nothing in the way of investigation for the penalty phase. So the issue of what the trial judge did, as far as saying, well, it wouldn't have made it, any difference, or it wasn't defective or deficient because it was a strategy. The case law says it can't be a strategy if he hasn't investigated mitigation. So we don't need to get into a dispute about how far-reaching Porter is. Case law that exists now and has existed would say that this defense lawyer was deficient.
I'm not disagreeing.
I wouldn't think you would want to.
In terms of, it's just that in the answer brief, the state was relying on Socher, which relied on Porter, as the standard. And in fact, that's what Judge Geeker did in this case, is he said, in my view, that mitigation wasn't credible, so therefore, there's no prejudice. And so, I think the standard review, but Your Honor, you're absolutely right, in that because this is an override case, this court has made it very clear that when it comes to the prejudice problem, the question is whether the mitigation would have precluded an override from being affirmed on appeal. And so would there be mitigation that would withstand an override? And the law on this, I mean, the mitigation that is presented here clearly would have precluded an override. And also, the attorney testified that he focused on the guilt phase investigation because his client told him he was innocent. If the client had said he wasn't innocent, then he would have done penalty phase investigation. And that, under the case law, has been unreasonable. And the U.S. Supreme Court also specifically addressed that in Porter and said there must be an investigation into mitigation.
Was there a second chair in this case?
No, there was no second chair, and no investigator was requested. And the case went to trial 90 days after indictment, 3 months from the indictment. So this was a very rapid case. In addition,
was then the time difference between the guilt phase and penalty phase?
actually, the penalty phase began the next day. The judge's sentencing was like 3 months later. It was in September. Right? The trial was in May, or it started at the end of May and went into June. But there was no break. And see, what Judge Geeker indicated is he said the strategy was to go for residual doubt. And that was reasonable, and it got a life recommendation, and that's proof that it was reasonable. But of course, the law from this court was it wasn't reasonable, but more than that, with that life recommendation, then you show up at the judge sentencing.
So tell us, what was the mitigation that would have negated our affirmance of the judge's override?
Among other things, an IQ of 67, learning disabilities, head injuries, his father's murder by his stepmother,
That's what he believed.
That's what he believed. The sexual abuse of him by a relative. The whole history of his life. I mean, it's a dysfunctional family upbringing that is quite compelling. And in addition, even Dr. Larson, the state's expert, agreed there was organicity. So there is brain damage. Any of that would have precluded the affirmance of the override.
You're seeking a new penalty phase, right?
Actually, under Williams v. State, in Williams, this court said, in this circumstance where there's a life recommendation, the life recommendation then continues forward, and the only issue is whether the mitigation precludes the override. And where there's this mitigation that's presented, this court actually ordered the imposition of a life sentence, saying that the override in Williams had been wrong. So under that standard, a new penalty phase is not necessary. The life recommendation continues on, and this court should order that had this mitigation been presented at the judge's sentencing.
In Williams, did we really explain why we did that? Well, that's what we did.
Right.
I agree. But was there any explanation of why it was remanded for imposition of a life sentence as opposed to being remanded for resentencing? Because there are other cases that are, the typical pattern would be to remand for resentencing when we determine that there's been ineffective assistance.
Correct. But in the series of cases in the override, and I know that I remember there's a Heine case. There's also
Did that fit this same fact pattern?
Well, it was a life wreck, and it involved a finding of ineffective assistance, and sending it back.
Well, they sent it back, but did they send it back for imposition with the directions to?
Your Honor, you may be correct in that. I remember the case in terms of it happening.
I looked at the cases you cited.
And I know that he got the life sentence if it went back for the resentencing.
Well, I understand that, okay. But I looked at the cases you cited, and the only one I could see that actually fit this pattern where this court said that that on remand a life sentence was to be imposed was the Williams case.
Okay. And that also may be influenced by Ray Thompson, which may not have been cited, but if you will remand it for the resentencing where I get the benefit of the life recommendation, I'll take it. So, I don't want to.
I mean, resentencing before the judge?
Yes.
Because are you saying, I mean, this is the issue, if your defendant gets the benefit of the jury's recommendation, life recommendation.
Yes, and in all of the cases, I think that was clear, is that the benefit of the life recommendation continued. So it's only a question of whether this court orders the imposition of a life sentence or it sends back to the judge to first consider it.
But in reading, and this is reading the judge's sentencing order originally, where he overrode, I could make an argument even back then with the little that was presented. There was you could argue there was a reasonable basis for the jury's recommendation. Now, obviously, the justices in cases that we really in this day and age we would probably uphold, even if there was a little bit of mitigation. So if it goes back, I mean, this is probably again another friendly question. The mitigation you presented would more than enough provide a reasonable basis for a life recommendation.
Yes. And so I think that to some extent that's what happened in Williams, and also in the Ray Thompson's case, where this court sort of took the approach that, well, yes, we can send it back for a resentencing, but if the judge imposed a death sentence, then it'd have to come back up here and we'd just reverse it. So for judicial economy purposes, let's just cut to the chase. And that's not expressed in Williams, but I think that's what this court may have been thinking.
I want to ask a question about with this situation, and I looked at the recusal issue. We've in the past always said, well, we encourage the same judge who tried the case to hear the post-conviction. But here, where really the challenge is that the judge may have erroneously overrode and had a pattern of overriding, should this court be concerned that in those situations, really another judge should be hearing those kind of cases?
Absolutely.
But we don't have any case law on that.
That specific issue has not been addressed.
Well, I mean, shouldn't we explore that a little further? I mean,
well,
it's an adverse ruling against your client. I mean, it doesn't necessarily demonstrate because the judge has ruled in a particular way. I mean, my goodness, we look across Florida, and in all kinds of cases, I mean, you say, well, that judge tends to rule that way. I mean, we're going to get into a situation where if that's the standard, most of the judges, because this guy's had a prosecutorial background, this guy was a public defender, this lady was such and such. Isn't that a dangerous?
I understand your position, and well,
it's not a position; it's a question.
Well, in the context here, I haven't specifically. If this court sends it back for resentencing in front of that judge, that's when I would file a motion to disqualify on that basis. And so, to some extent, we're talking about a motion to disqualify that I haven't filed yet.
Well, you have already filed several, though.
I have already filed, and those concerned the reappointment of Bia Harrison to continue on the case when this court had ordered that inquiry. And so, those motions didn't specifically address sending it back to the same judge to consider the override. And so.
I mean, it happens all the time. If a trial judge rules on something, a summary judgment, it goes on appeal. And if we would allow you to say, well, that judge has entered a summary judgment, ruled as a matter of law, I cannot win, therefore, that judge should be recused. I'm not sure that that this argument or position is a logical one that flows, that can be applied as a principle of law that we deal with.
I think to some extent what we're all addressing here is the fact that we know the mitigation is going to give a reasonable basis to the life recommendation. And so what is the proper way to proceed in terms of, should this court just say that? Should this court send back for a judge to do the resentencing, and should it be in front of the same judge, and then have an appeal come up if somebody imposes death, where then this court then says it had a reasonable basis. So it's sort of, I guess, a question of judicial economy and which is the best approach. And on some level, my answer is I'll be happy with any of them because I know that I'll prevail once I'm in that position. But I want to quickly address the Appellate IAC claim. A 27-page initial brief was filed in this court. Did not address the DNA evidence. And there are 3 DNA issues that were at work. One involving severance. Robinson, the co-defendant, had a DNA match. His defense was to attack it, attack DNA as unreliable, and obfuscate Mr. Coleman, who had an exclusion. So the interest between the two was opposed. A severance should have been granted. The issue wasn't raised. The jury had a question. What did the DNA show as to Mr. Coleman? Was his DNA present? Simple yes or no answer. The judge refused to answer the question, told them to rely on their memory. If they ask the question, they're confused. It was wrong not to answer the question. And then the sufficient evidence itself should have been raised. I submit that that was an appellate ineffectiveness. There was no reason not to include those, particularly when the brief was 27 pages. And since I'm into my rebuttal time.
I have a question actually about that, just from a procedural point of view. If you're asking us to either remand for a penalty phase or to reduce to life, procedurally, what happens to looking at the errors on appeal in the guilt phase? Is that done, should we do that at the same time, or do we wait because there might be another appeal? I'm not sure.
I recognize on some level these issues are sort of going off in different directions. I think I'm entitled to the resentencing in the penalty phase IAC. I also think in the habeas, at least a new trial should be ordered. And if I prevail on the sufficiency of the evidence, obviously that would vacate everything. But at a new trial, this court has made clear, I believe the case is Mack Wright, that even if a new trial is ordered, a complete new trial, the life recommendation remains, and that benefit would continue. So I hope that answers your question. Thank you.
Steve White, representing Appellate, the state. A number of comments on opposing counsel's argument. One, regarding Porter. Now, I want to address the specific allegations that counsel has made regarding the additional mitigation that he purports would have made a difference. I do want to address those, but leading up to that, on Porter, it's clear in Reed, which I supplemented with last week, the 11th Circuit made abundantly clear that Porter is limited to the situation where defendant had an extensive military service. Porter received medals, was involved in combat in Korea. The Porter opinion discussed the battles and his heroics, the medals that he won. Clearly not this case. It's clearly not that magnitude. In fact, as the state argued in its brief, the post-conviction evidence in this case would have affirmatively harmed the defendant. Getting to Justice Perriente's question about counsel's preparation, although I would argue that the prejudice prong is the state's stronger argument, as the trial court found, counsel indeed was not deficient, that counsel did go to Miami in preparation of the penalty phase as well as the guilt phase. He said he was primarily focusing on the guilt phase.
I mean, the problem is that the judge's finding is that what he said is that his trial strategy was to focus on the guilt phase. There is no evidence that he did any investigation on the penalty phase.
I would disagree with that, Your Honor. The defense counsel Stokes testified at the post-conviction hearing that he did discuss the penalty phase, the defendant's background in Liberty City with the mother and the girlfriend, Ms. Tukes, while he was in Miami. That yes, his primary focus was on the guilt phase, but he did address the penalty phase while he was in Miami.
And I think we have in the record the exact statement. I mean, what he said is, he said, the only thing I can recall is just growing up in Liberty City, which is enough. That's probably the most horrendous place, but I don't know of anything specific. Isn't that what his testimony was on that?
Well, I mean, his recollection at the 2001 hearing regarding the 1989 trial.
What is it? Did he hire an investigator?
He did not hire an investigator.
Is there any evidence of time billed for investigation into the penalty phase?
We don't have any billings at all, Your Honor, one way or the other. I mean, it cuts neither way.
And about this particular lawyer, the judge did not allow any evidence about the fact that apparently during the time of this trial, he had a serious alcohol problem and was drinking on a daily basis. I understand there can't be ineffective assistance of counsel, just the person's, was drinking. You got to connect it with the deficiency. But if you're really looking to try to explain why a lawyer would act the way the lawyer did in this case, devote no time to the penalty phase, essentially. Isn't it relevant? I mean, we talk all the time about lawyers who are, first-class lawyers, and they've handled many death penalty cases, and we go a lot, detail into their background to say, well, we can give this some credibility. Doesn't it go to sort of the whole issue of what his state was during the time of his preparation?
Your Honor, absolutely not. In fact, during the post-conviction hearing, in terms of establishing the defendant's burden of establishing that Mr. Stokes was under the influence in the trial or while he was preparing, and that impeded his conduct and caused deficiency. During the post-conviction hearing, Mr. Spencer, the prosecutor, turned to defense counsel and said, Mr. Pitts is in the courtroom right now. If you want to try to prove that Mr. Stokes was under the influence during this case, Mr. Pitts, who was co-counsel representing Robinson, and Robinson was tried with Coleman, Mr. Spencer said, you have the burden, so you call post-conviction counsel for Coleman, you call Mr. Pitts to the stand and ask him whether there was any indication Mr. Stokes was under the influence. Post-conviction counsel didn't do it. The burden was on them to establish that linkage, to establish the under the influence, and to establish the linkage with
I thought the judge precluded the defendant from putting that evidence on.
He precluded the documents and sealed the documents, which I can go document by document if you'd like, in terms of showing that at most what they've done is they've resurrected the documents in Bryan, which this court expressly addressed in the Bryan opinion and said, no, you haven't met your burden. Many of these same documents, the court has ruled on those documents.
In Bryan, there was no deficiency alleged. Here, we have the deficiency alleged of no investigation, and the judge is saying, well, that was a sound strategy. Well, in terms of evaluating whether the person acted reasonably and in accordance with professional norms, just seems it's a fact that should be there. But that's we don't. So I'm agreeing with you that you can't just throw it out there. But I just asked the question: wouldn't it be relevant to a determination?
Counsel was in the middle of a divorce. Are we going to get into whatever's going on in his personal life, which could have, against speculation, could have impacted what he did during the trial? I mean, the door would be wide open if the court allows it in this case, especially when the court expressly rejected that evidence as irrelevant in the second Bryan opinion in 2000. In fact, a number of the items that they've attached indicate that counsel had just succeeded in going through alcoholism rehab about the time of the trial. So if anything, it weighs towards counsel not having the alcohol problem during the trial or the trial prep. Of course, I respectfully disagree with Your Honor's characterization that counsel did nothing and that there was no basis whatsoever for the trial court's conclusion that it was a strategic decision. That pertains to not hiring the mental health expert, and counsel testified that he didn't see anything mentally wrong with the defendant whatsoever, that he was bright, articulate.
Let me ask you this about that. We know that in most of these cases, we have school records that are obtained about the defendant. We have records from correctional institutions that are obtained about the defendant. We normally get any drug information about these defendants. And did we have any of that in this case?
Counsel, the only records that were introduced at post-conviction were the school records. So in terms of what other records might have been available for defense counsel to get at the time of trial, they haven't proved up. It was their burden, and they didn't prove it. All they proved up were the school records.
School records demonstrate. I mean, we know that there was no investigator. We know that there was no mental health evaluation.
That's correct.
And so
no basis
what did
for
the school records demonstrate?
Again, no basis for getting a mental health evaluation. Versus Williams, by the way, where counsel filed a motion to have the defendant examined and said there was a basis for believing that he was mentally ill or had some sort of mental illness. But in terms of school records, interesting point. The school record, this gets down to some of the nitty-gritty details of what they claim defense counsel didn't get. The father dying, supposedly, according to the post-conviction evidence, had a material impact on the defendant's demeanor. He supposedly started getting in trouble. Well, what do the school records show? No. The school records show that the defendant had behavioral problems, but the father died in December 1972. The school records show the defendant had behavioral problems before that in school.
Correct me if I'm wrong, which prong we're looking at. If he doesn't do an investigation into a mitigation, he can't be reasonable in how he decides to proceed. So it seems, and you had said earlier, your better prong may be the prejudice prong. And I appreciate it, but it just seems this is a classic case of deficient performance. Now, as far as whether it would have, quote, made a difference, that's, I thought, what you were getting, that there's really, after they did all this, found out he had at least one expert said he had a 67 IQ. That was...
Which the trial court rejected.
I understand, but 67 IQ is at least it's somewhat of a significant finding in terms of mitigation. Might obviously was a basis to try to make a claim under Atkins. But what I'm asking you is, since this was a jury override situation, wouldn't the presence of any of this mitigation have been the basis for this court to have reversed the death sentence that this judge imposed and imposed a life sentence under Tedder?
Well, getting to the remedy, what they asked for, the remedy they asked for from the trial court, is a new penalty phase. They didn't raise before the trial court the claim that they're raising now in terms of the remedy. And the state's contention is, as I mentioned in the brief, under issue 1, is they should be bound by the remedy that they requested from the trial court, because this can get us into a whole discussion of the interrelationship of Caratelli to the Williams case. And the state's contention is that Caratelli should be adhered to, and that IAC, the burdens on defense for IAC, should mean something, that it shouldn't just be a totally de novo review, that there's a layer of protection that Strickland provides on defense counsel, and that just shouldn't be totally discarded, as Caratelli discussed. But the remedy they asked for in terms of IAC penalty, I think in both of their memos, post-evidentiary memos, is a new penalty phase. Didn't say new Spencer hearing. By the way, Spencer was in 1993, which was after this trial. And so the importance of Spencer in terms of the impact on defense counsel, it could not have impacted defense counsel at that time. The trial was in 1989. And of course, we're also hindsightedly evaluating defense counsel in terms of his decision not to hire a mental health expert. Now, a defense counsel should realize the court would prefer a mental health expert in just about every case. Of course, there's contrary case law in Mills and Duckett, where if there's no basis to believe that the defendant is mentally deficient or mentally ill, that you're not obligated to get a mental health expert.
Counsel, but in the new penalty phase, let's assume that there was ineffective assistance of counsel. Is there anything as a matter of law that prohibits the remand for a new penalty phase? Is it wrong as a matter of law?
Assuming that you find both prongs of Strickland, that you reverse the trial court's finding of no deficiency and you find that there's prejudice. The court's done it, and not in override cases that I know of. But
did you say not in override? I mean, isn't there a double jeopardy issue?
The short answer to your question is no, I don't see any legal part to it.
Is there a distinction about an override case that, as a matter of law, that it would make it inappropriate or not proper for a new penalty phase trial?
My gut tells me no, but I have some hesitation because there is a jury finding. It's 6-6 in this case versus Williams, by the way, which is 11-1. So if I may...
What did you say? You said this was 11-1?
Excuse me, Williams was 11-1.
Okay, and this was 6-6.
This was 6-6.
Okay, all right.
Yes, sir, I'm sorry.
But hasn't the typical pattern been that we remand for a resentencing before the judge?
Correct. Well, The error in this case...
With the benefit, with the defendant having the benefit of the jury's life recommendation.
I think that's the better argument, yes, Your Honor.
I mean, that's just what the cases do.
Yes, sir. In terms of their attacking defense counsel's actions post-jury, and so it seemed, I mean, I think the argument can be made, a compelling argument, that the remedies should match what they're attacking, that is, be post-jury. And we do have a finding by the jury recommending life.
Right, because
so
I mean,
that's
if
the better argument. I'm not conceding that point, but
but I think there may be a double jeopardy issue, because when if we reverse for new guilt phase, we have always said they get keep the benefit of the life recommendation. I mean, it's not happened that many times, but that's what the case law says.
of course, I mean, my contention is that especially on the prejudice prong, they fail. But I mean, may I resume discussing their specific mitigation, if I could?
I think your argument really is that you fell on both points, and I'm really concerned about certainly the performance of this defense attorney. And
well, again,
you have not convinced me that he did anything.
I respectfully
really
disagree.
Helpful for the mitigation stage.
That there is competent substantial evidence to support the trial court's finding that defense counsel did prepare. He did go to Miami. He did talk to the mother and the sister about mitigation. He relied on, not the sister, the girlfriend, Ms. Tukes. He did rely on her to get records. The only records they show that he did, let's look at what he supposedly didn't get. What he was supposed to get and didn't get, the only thing they proved up are the school records, which gets back to that discussion. In terms of what they put on in terms of mitigation, they put on the mother. The mother testified at the penalty phase to many of the same facts that she testified to at post-conviction. She did talk about the father's death, for example. And the father's death gets back to the school records. The school records show that the defendant, there's no break in 1972 before and after. I would contend if you examine the school records in terms of the defendant's behavior, he had behavioral problems before the father died. He made A's, B's, and C's before and after the father died. After the father died, I think he had an A in math and a B or C in science. I mean, these just weren't phys ed, what have you. So that the school records actually contradict the mother's testimony. In terms of the mother's testimony, also a major factor that distinguishes this case from Williams, as well as the HAC, which I do want to talk about here, versus Williams, is Dr. Larson testified about antisocial personality disorder. And here he weaved in the notations in the school records that the defendant was having problems throughout his school tenure. The defendant was Dr. Larson said, fighting and truancy. In fact, the defendant was able to deceive his mother into thinking he was going to school when he wasn't. And Dr. Larson said that's another characteristic of antisocial personality disorder. So the defendant, in introducing these school records, if they're saying, hey, these are the school records that defense counsel should have gotten and should have introduced, well, that would have opened the door, among other things in the post-conviction evidence, to Dr. Larson testifying about how those school records help prove up antisocial personality disorder, which, of course, is a heavy negative against the defendant. Dr. Larson went on for pages in the transcript describing the defendant's behavior meeting the diagnosis of antisocial personality disorder. In terms of the
school records used by was it Dr. Toomer? Was that the other doctor that
yes, Your Honor.
testified? And he actually was the one who had performed the
67 IQ test.
The IQ test, and weren't these records also used by him for his diagnosis of this defendant?
I believe he did look at the school records, Your Honor, but he did not review the trial transcript, which showed the defendant testifying in the guilt phase and the penalty phase for pages and pages and pages. And the trial court relied on this in its order, and Dr. Larson also relied on this in his opinion that the 67 is an underestimate of the defendant's IQ. He was articulate, responsive.
Which brings up an interesting point. Is I don't recall seeing this in any other case where a professional uses scores that someone got on a math test or a science exam to indicate that to negate someone's IQ. I found that very interesting. Have we ever used that kind of testimony to say, no, this isn't someone's IQ because they did something different or better on a test?
Your Honor, he testified, and short answer to your question is I don't know of a case on point, but this was a factual finding by the trial court. Dr. Larson testified to that. It was unrebutted as such in the post-conviction evidence. And Dr. Larson also, in addition to those two achievement tests, he said basically, no, people with a 67 wouldn't score this high. I mean, you can fake malingering, you can fake a lower score. You can't fake a higher score in achievement or IQ. It depends on motivation. And Dr. Larson also pointed to the defendant's trial testimony, as the trial court relied on also. He said, this is not the testimony of somebody with an IQ of 67. Dr. Larson's been in the business a long time and spoke as an expert. And the trial court relied on Dr. Larson's testimony, accredited it, and there was competent, substantial evidence to support the trial court's adoption of Dr. Larson's opinion, which is the test. But Dr. Larson pointed again to the defendant's trial testimony. Again, Dr. Toomer did not look at the transcript, did not review the trial transcript.
Dr. Toomer is the one who actually performed the IQ test on Mr. Coleman, correct?
Right. Here we've got Coleman in the courtroom where everybody can see him, and he is now motivated to testify in an articulate manner to convince the jury to find him not guilty, unlike a test where sometimes they're frequently not motivated. In fact, they're motivated to perform poorly. So with him in the courtroom, with the judge eyeballing him, and with Dr. Larson reviewing that transcript, and he's using terms like disassociated myself and my girlfriend. He's performing mathematical calculations. I gave my girlfriend $1,200 and she spent $700 and I got $500 back. And he goes on for coherence, says grammar's not the greatest.
Your time's now up. You need to wrap it up in about 30 seconds.
Yes, Your Honor. I'm sorry. Regarding the sexual abuse, real quickly, the mother testified to that at post-conviction, but she didn't testify when that information was available. And so there's no proof that that information was available for defense counsel. The state would request that the court affirm the trial court's denial of post-conviction relief and deny the habeas, and I would stand on for the arguments on the habeas on my response. Thank you.
First, the state's asking this court to ignore Porter v. McCullum. And that's why Porter v. McCullum is so important. He's relying on Judge Geeker's credibility findings.
But he can do that for the Atkins issue.
On the Atkins issue.
Okay, I thought that was maybe he was.
I thought he was talking about the prejudice prong and saying Dr. Toomer's testimony alone means that an override could not occur. If Dr. Toomer had testified, life wreck, judge overrides. Whether Judge Geeker credited Dr. Toomer or not, this court's law is that the jury would have had a reasonable basis because the jury can have a different credibility finding. And so Dr. Toomer, whether the state agrees with his testimony, whether Dr. Larson agrees with his testimony, or Judge Geeker, his testimony alone precludes an override. And as a result, it establishes prejudice. And the arguments that Judge Geeker didn't credit the school records, credited Larson, all of those, Porter v. McCullum says, you can't do that. You can't rely on that. This court has to consider the mitigation, even if the judge presiding at the hearing.
Do you interpret the follow-up to those cases with regard to the military that in such a limited way that applies only to military records?
No, I mean, it's just basic. How law is done is, yes, there were military records in that case.
Well, I understand that. I'm just asking, is that...
But when you read the opinion, they're saying, and you go through what they found to be unreasonable. Specifically, they say, discounting Dr. D's testimony was unreasonable. And that's not about the military records. That, when you look at what this court had done, was based on what the trial judge had done. And the trial judge,
your opponent says that the 11th Circuit has now determined that decision applies only to military background. Do you believe that's the case?
And certainly, Sears v. Upton which is the U.S. Supreme Court decision at the end of June, the last day of the term, also says Porter is the law, and it applied it to somebody who was not in the military. I also want to just address the alcohol. Mr. Stokes was on the witness stand, and he could not be impeached with the alcohol in terms of his memory. When he testified, I didn't see a basis for thinking there was a problem with Mr. Coleman's intelligence. A drunk lawyer may not recognize that his client is mentally impaired. And you should be able to ask that question, and that was precluded. You should be able to ask, when you went to Miami, were you drinking? Did you ask the mother about the family life? Did you ask those questions? There's no indication he did any investigation at all. And his use of alcohol and his alcohol problems is very relevant to his memory, to the reliability of his memory, and also to his fear of problems with the bar if he admits to more, because he'd already gotten in trouble, which is Davis v. Alaska. I would ask this court, one final point, if this court were to agree with me that a new guilt phase would be warranted on the appellate IAC claim, Mac Wright, I believe, it's Wright v. State. I think it's like from 92. It's not mentioned in the brief because it just hadn't thought of it. Is I think the case that says there is a double jeopardy protection that attaches to the life recommendation. So I think that's the case to look at. And I think Your Honor had Justice Perrienti had mentioned that there were a couple cases, and there may be another one, but I think it's Wright v. State. In any event, I would ask that this court find ineffective assistance of counsel as to the penalty phase. I would also ask this court to find ineffective assistance of counsel during the direct appeal. Thank you.
Thank you. The next case on our docket is Camponi versus the City of Tampa.
Good morning. May it please the court. My name is Joel Eaton. I represent the petitioner Ramiro Camponi. At counsel table with me is Dominic Ferriello, who represented Mr. Camponi in the District Court of Appeals, not in the trial court. Mr. Camponi was injured in a motorcycle accident involving a City of Tampa Water Department truck. He brought a personal injury action. The case was tried to a jury. During the course of the trial, City's counsel complained of plaintiff's counsel's misconduct in several respects. He objected. The trial judge sustained the objections. There were no motions for mistrial made. The trial judge all but invited counsel for the city to make a motion for mistrial on 4 separate occasions. Counsel for the city declined to do so. He chose to wait and see what the result in the case would be, confident that he was going to win based on the evidence, but he lost. The jury returned a verdict favorable to Mr. Camponi. The city moved for a new trial. The trial judge wrote an order in which he said counsel for plaintiff did engage in misconduct. The city was deprived of a fair trial, but the complaints were not preserved for review because there was no motions for mistrial made, and I do not find that plaintiff's counsel's misconduct amounted to fundamental error. It did not so undermine the public's confidence in the judicial system that fundamental error occurred, and therefore I denied the motion for new trial.
I want to ask a question about your point is that they waived any ability to get a new trial based on a lesser standard by not moving for a mistrial before. What would be the standard if they had moved for a mistrial? What's the standard for during the trial for a mistrial to be granted? Is it what the judge said, that is that he's being denied a right to a fair trial? Or
No, Your
you're
Honor.
not ready to answer that?
I smile because you use the word standard, but a motion for mistrial is a discretionary ruling, and it's kind of hard to say what the standard is.
Well, the standard of review is discretion, but I think we have used words about what it has to be to grant even a...
This is not something that I briefed, but from my recollection,
Well, then
a motion for mistrial is something that has to be incurable, couldn't be cured with a curative instruction, and so harm the integrity of the trial that it has to be stopped in its tracks. Probably similar to the fundamental error description that this court laid out recently in the Murphy versus International Robotics
So it would be
Systems
whether
case.
the error, because this is whether the error is so pervasive or prejudicial that the injured party is denied the right to a fair trial. The judge found in this case in the motion for new trial that the defendant had met that standard. And when I read that standard, that sounds remarkably like, at least in a criminal case, the standard that we use for fundamental error. That is, that it's so pervasive and prejudicial that the injured party is denied the right to a fair trial. And my concern is, first of all, we're about mixing civil and criminal, and then what we're saying really constitutes fundamental error that would give somebody a new trial where they haven't preserved their objection.
In the 35 years that I've been practicing, the term fundamental error was what they taught us in law school was the length of the chancellor's foot. And I think that the court resolved the concept of fundamental error in the Murphy case.
In a civil
In the
situation.
civil context, fundamental error now has a standard. It's not how long is the chancellor's foot. It's not how aggravated the court is. In order to prove fundamental error after Murphy, you got to prove four things to the satisfaction of the trial judge: that the conduct was improper, that it was harmful, that it was incurable, and that it so damaged the fairness of the trial that the public's confidence in the judicial system is undermined.
All right, and it's that fourth prong, and I know that's in Murphy, that I just would be concerned that if we say that's part of fundamental error analysis, that's not, is what I recall to be the standard in a criminal case, that there has to be that the public's confidence is impaired. We're really looking at whether the defendant, in a criminal case, whether the defendant's right to a fair trial has been compromised.
Well, you know me, Judge. I've been here so many times, you know I don't know a thing about the criminal law.
All right, but your point here is that we have to treat this case as if they had not made as if any further objection was waived, because after each objection, which was sustained, they had an opportunity to move for a mistrial. And in fact, as you quote in your brief, the judge not only asked them, but they said, no, I don't think I've been so prejudiced that this can't be remedied. So that essentially they waived any right for a mistrial. Is that your position?
Yes, and what the trial judge said in essence, and this is not exactly his words, is based on the normal standard of review here, had the error been preserved during trial, I would have granted a new trial.
Preserved by a motion for mistrial, which would seem
Correct.
to me that the standard for motion for mistrial would be the same before as, after. Because in cases where they can reserve, like based on the Ed Ricks case, the judge usually would say, motion for mistrial I'll reserve, and I think it would be that standard that the judge would apply in deciding whether to grant a mistrial or a new trial.
Well, the interesting thing about a mistrial is that there is no appellate review. So there aren't any cases involving a mistrial that was actually granted during trial. All the cases dealing with mistrials are cases in which the trial judges have denied motions for mistrial, and they come up to an appellate court, and the typical ruling is no abuse of discretion. So that's a fuzzy area in the law. But the point here is...
Well, it's not very fuzzy, because the case out of the 2nd District, Kasagawa, which refers to Hagen, says the legal standard in denying a motion for new trial is whether the error is so pervasive or prejudicial that the injured party is denied the right to a fair trial.
For preserved errors.
Correct. So that would seem to me, this, and I'm sorry to use any more of your time, that would seem to me to be the standard for a motion for mistrial or a standard for motion for new trial if it was preserved.
If it was preserved, yes.
Can we go to what really appears to be the heart of the dispute here?
I'm sorry, louder, please.
Can we go to the heart of where the dispute is, and that is the cases seem to be legion, that to be able to take this up on appeal, you do have to move for a mistrial. You agree with that?
There's no question. That's
right.
settled.
Okay, that's settled. So the question is there a different rule with regard to a new trial? Should there be? Why should there not be? I think that's really where we are here. That's the gray area, it seems to me. Is it a different standard? Is it the same? What is it when it's at the new trial stage, motion for new trial, as opposed to on appeal? Because we know the on appeal is settled, I think, pretty clearly.
What the second district held in this case was, because the errors were not preserved during trial, had the judge, an appellate court could not reverse.
Right.
But we can order a reversal because even though the issues were not preserved prior to trial, the trial judge had the authority,
right,
greater than an appellate court, to reverse an order.
Well, that's what I'm asking. That seems to be what we're talking about here.
That's where the dispute lies.
Right, and I'm saying, why should we not allow a trial judge, in your view, to have that power? Because this conduct is going on in the presence of that trial judge.
I've cited at least 50 and perhaps more cases, decisions from the various courts in this state which say that a trial judge has no greater authority than an appellate court to reverse an order for a new trial.
That's the fundamental principle that undermines all this.
And there are, at present, 4 outlier cases, 1 out of the 4th and 3 out of the 2nd, which hold to the contrary. Now,
but let me ask you this. The trial judge is, in fact, the person who sits there when the parties made their objection the first time he heard it. He heard all the objections that were made, and the trial judge was there to sort of see the impact of how all of this played out. So why shouldn't the trial judge, who is in that kind of position, have the authority at the end of the day to say, look, I have watched all of this, and really, everything that went on cumulatively has denied this defendant or plaintiff or whichever side it might be a fair trial in this case.
if the trial judge were to reach that conclusion, he or she would have made a determination that fundamental error occurred. Fundamental error is error that wasn't preserved for review, but that motivates me to order a new trial.
It's disturbing because the trial judge gets to the point of saying that, all of this misconduct really did deprive the city of a fair trial. So why not?
But the
under
trial
those
judge
circumstances, allow the trial judge to make this kind of ruling.
Because the trial judge in this case said, but I don't find that fundamental error was created, and because the issue was not preserved by contemporaneous objections and a motion for mistrial, I can't grant a new trial unless I find fundamental error, and I don't find fundamental error. And what the district...
It seems to me that I'm just saying, it seems to me that what he said is pretty close to a finding that
Well, it is, but the point, Your Honor, is that had it gone to the second district, on the grant of a new trial, it would have got reversed, because the second district would say it wasn't preserved for review.
But the policy, again, this is what the issue of whether it's not preserved is so different to me when nobody objects at all versus when they've objected and then sustained the objection. You would agree that a trial lawyer, and this case is important, I think, to plaintiffs and defendants. It may help or hurt the defendant or plaintiff in this case, but it's a lot of times plaintiffs are looking to get relief after a verdict goes against them. So we've got to look at that. And I'm concerned, and that's why I had asked you earlier about the standards, to equate, and that's what the standard for the judge in granting a new trial after there had been repeated objections and they were sustained, to the Murphy standard for granting a new trial based on fundamental error where there had never been one objection during trial. There seems to be that because the judge, as Justice Quince is saying, is the reason we gave the judge even that authority in Murphy was because the judge is there. There's so many cases that talk about why they have greater discretion to grant, as you said, a mistrial or a new trial. So what is the policy for why we should treat motions where the judge has sustained the objection and there has been no motion for new trial exactly the same as if no objection had been made during the entire trial?
The reason for both the contemporaneous objection rule and
But there was a contemporaneous objection here.
and the requirement for a motion for mistrial if you got the relief you asked for when you objected, is that you got to get an adverse ruling from the trial judge before you got anything to complain about. No adverse rulings occurred to the city in this case because they never moved for a mistrial. What they did was they sat and they waited. They said, we don't want a mistrial. We're content to go to the jury on this record, despite all our objections. We're going to wait and see what happens.
Well,
If we get a verdict,
under the Ricky case, they could have actually moved for a mistrial and asked the trial court to reserve ruling on that, and they said but then the trial judge would have been in the position to decide how to handle that. But they could have actually gotten the benefit of moving for a mistrial and yet letting the jury rule with the ability of the trial judge to come back and say, well, I'll grant a mistrial anyway. Is that right?
that's a good point, Your Honor. And I have argued that Ed Ricky and Sons is inconsistent with the Second District's decision in this case.
So the bottom line is that we have to assume that even though there were objections that sustained, that essentially this was an error-free trial because the judge cured through the objection they made and sustaining the objection, cured any problem, and if there had been an additional problem, the party needs to bring it to the judge's attention before the verdict.
Yes, Your Honor, but the reason why an appellate court can't reverse if the error hadn't been preserved is the same reason that supports the rule that a trial judge can't order a new trial when an error hasn't been preserved. And that is expressed in the cases that counsel can't be allowed to wait and see what the result is, and if he wins, he says nothing. If he loses, then he springs on the other side, and he sandbags the court, and he sandbags the opposing party by raising his objection after the result is in. And on pages 9, 10, and 11, I have collected a dozen cases which say Altos cannot be allowed to proceed on a heads I win, tails you lose basis. The reason for the motion requirement is to preclude an attorney from sandbagging the court and his opponent.
Mr.
And they go
you
on and on and on.
You're now into your rebuttal. You can continue if you like.
Let me just refer the court to it. I thought this question was put to rest about 27 years ago in the late Judge Daniel Pearson's opinion in Sears, Roebuck and Company versus Jackson, which has been followed by all the district courts.
Didn't we disapprove of that in Murphy, and doesn't it have to do with an error that was never objected to?
The disapproval in Murphy of Sears, Roebuck and Company versus Jackson was limited to Sears holdings that review was de novo. Murphy says no, review of an order granting a new trial for fundamental error is discretionary. There is nothing in Murphy that touches on the principal holding of Sears, Roebuck and Company versus Jackson, which is that there is no authority for a trial court to have greater authority than an appellate court to order a new trial. And there's at least 50 cases cited in my brief here that say essentially the same thing. There is one outlier case out of the 4th District in which Judge Klein wrote an opinion which says even though an appellate court can't reverse, a trial court can order a new trial. It's called Negro versus Brady. Negro was followed in the 2nd District in Robinson versus State. It was followed in this case, and it was followed in a subsequent case that was sent up here in a notice of supplemental authority by the 2nd District. Those are the only 4 cases in this state out of 2 districts that have ever held what these other 50-plus cases have not. And I'd like to save my remaining minutes. Thank
Mr. Eaton, could I ask you one quick question? That is, the 2nd DCA found that the trial court was wrong, so they said that preservation occurred where the trial court said it did not. So the 2nd DCA really never got to evaluating whether the trial court was wrong or correct in its fundamental error analysis, right?
That's correct.
So if we were to find for you, then wouldn't we have to remand it back to the second DCA for them to further evaluate that particular issue, whether or not fundamental error was proper or not by the trial court?
I'm reluctant to suggest that that's an appropriate course, because what the city argued on appeal was my position, that they had to prove fundamental error. Their brief, if you go back and read the second district briefs, they argued fundamental error. The district court did not find fundamental error. The only thing it found was the trial judge applied the wrong standard, and it sent it back. But they've argued fundamental error here as a right for the wrong reason rule. You can read the 6 things they're complaining about. To me, they don't represent prejudicial or inflammatory conduct.
Well, isn't there other grounds, though, that the second district never reached, like manifest weight of the evidence? I mean, we're still in this case, still on the question of whether new trial should be granted. Has there even been the first appeal of the actual verdict, or is there, we're still on post-trial motions in this case?
I'm sorry.
I mean, weren't there other bases that they argued their motion for new trial, such as it was against the manifest weight of the evidence and other grounds?
Yes, there were.
And those haven't been resolved.
You don't have to send every case back when it's decided on one issue. All you got to do is take a look at the legitimacy of these cross issues on appeal. In my judgment, they're frivolous. Why should we have to go back to the second district? Let's get this case over with. Mr. Camponi's been waiting an awful long time for justice in this case, and I'm about to run out of time. Thank you.
May it please the court, my name is Richard Zabak of Gray Robinson, and with me today is Monterey Campbell. We are privileged to represent the city of Tampa. If I might start off addressing the questions by Justice Periente and Justice Poston about the other issues. There are other issues, including the fact that the second DCA did not reach the heightened, the heightened standard in Murphy, if this court deems that it applies, and the sufficiency of the evidence.
Well, if the second district had thought this case ought to be over, and those points were raised, it seems to me they could have just very easily said this evidence doesn't support it and you all go home. So, yes, I mean, it was presented for their consideration, yet they must not have felt that, or they wouldn't have talked about just the motion for a new trial, would they?
I don't know.
They wouldn't give a new trial if you're entitled to go home.
Well, interestingly, Your Honor, it's the same sort of thing that happened at the trial court level. In fact, this case has been up and down twice because the trial court level, initially the trial judge, we raised, I think it was initially 5 grounds for a new trial. The trial court only addressed 1, and then we went back and the second DCA remanded initially for consideration of the other 4, and that's how this case comes to this court. So,
well, I understand, but again, and let's break this down, is that if there had been, if this is totally against the evidence in this case, and
yes,
you're
sir,
entitled to a judgment, why in the world would the second district, if they thought that, they had the issue there, have sent it back for saying you're entitled to a new trial? I mean, this is just, to me, just crazy.
I understand what Your Honor is saying, but in point of fact, that the opinion is silent on the other grounds.
Well, many times they find they're without merit and they just don't address them. I mean, I've been doing this for 35 years.
Yes, sir.
And they don't address points that are without merit. I mean, because really, if you're entitled to it, we're just spinning judicial wheels. I mean, that's, yes, what you're saying is second district's just going, we're going to retry it, even though they felt there was no evidence.
And I guess, Judge, what I'm saying is unfortunately, I guess sometimes that occurs because that's exactly the parallel scenario that happened at the trial court. But I will say this on the sufficiency of the evidence, that actually ties in, regardless of whether this court wanted to review it as an independent ground, it ties into the ground that the second DCA ruled on. Because if you look at the order that Judge Bauman entered, the trial judge, if you look at the order that he entered on why he found that there was no undermining of the judicial, of the confidence in the judiciary, which is the last prong in the Murphy case, the only reason he said that it didn't reach that level was because there was sufficient evidence. And Your Honor, we argue in our brief that clearly there was not sufficient evidence here. And I don't want to get sidetracked because I know that's not the issue that you are focusing on, but there's not a scintilla of evidence. There's no showing whatsoever of a sudden an unexpected lane change, which is what is required. In fact, the evidence shows you got some slow trucks in the highway.
Have you already, like, has there been an appeal from just that whether there were errors during the trial, or was that all part of what your appeal to the Second District was?
No, the first appeal had to do with a totally independent issue, and that was that there were two jurors that sat in this case that were convicted felons that didn't disclose their felonies. Right. And the trial court actually granted that on that ground, granted a new trial on that ground, but the second DCA reversed that because it didn't find that there was a linkage between those two jurors sitting on that trial and the result.
Getting to this, the issue in this case, I might be somewhat convinced about the question of when someone moves for a mistrial during a trial. You know, you've got a situation where it's opening statement, there's some problems, you go along, you get what the judge, you keep on objecting, and there comes a point where you see as a trial lawyer that what is happening now is undermining the fairness of the trial, and it's a standard, but it's also it's a cumulative issue. And of course, in criminal cases, almost all defense lawyers know you've got to, when you object and that objection is sustained, you then move for a mistrial. It's or a curative objection, and then, but if it's overruled, you don't have to. Here, on page 3 of the brief, and I'm sure it's in the record, he wanted to hear the judge whether you were moving for a mistrial, and the lawyer specifically said, "I'm not moving for a mistrial at this time because I don't think my client has been so prejudiced this cannot be remedied." Yes. And the whole idea of a mistrial is that the lawyer bringing this to the judge's attention is saying, now I think that the conduct or the problems have become so pervasive that what you've done by sustaining the objection can no longer be remedied, and now I have to move for a mistrial. And then the judge decides whether, wow, yeah, you are correct, what has happened has undermined the fairness of this trial. I'm either going to grant it or, as Ed Rick says, if it gets to close to closing argument. But doesn't this all depend on the trial lawyer providing the judge with that opportunity by preserving what they say is an unfair trial and not being able to wait till after a verdict comes back?
Yes, Your Honor, with this caveat, the record citation that you mentioned, I believe that happened on the morning of the second day of the trial, relatively early on. If you look at Mr. Terry's comments later on during the course of the trial, the later conduct, because it persisted, and that's the problem with this case. You don't have one single event that triggered this.
But then he asked later on, it's getting cumulative, I want it on the record, and the court says, well, I sustained it. You have any other motions? It's almost like this judge is just waiting. Mr. Terry, do you want a mistrial? Because, and that maybe what happened is Mr. Terry was concerned that the judge wasn't going to reserve, that the judge felt things were getting so unfair that he was going to grant it, and Mr. Terry didn't want to do that. So I don't see how it's preserved. I mean, initially I was sort of sympathetic to your position, but as I look at it, I say, it seems to me that this is a decision the trial lawyer makes, that what has happened by what the judge did remedied any error. And if they thought any other relief was required, they have to make a further motion.
Well, later on in the trial, let me just point out, because it ties in with the Ed Ricky case and the considerations that this court enunciated there. Later on in the trial, when it did become later in the trial, the reason that Mr. Terry gave for not moving at a mistrial at that time is that because of the expense that his client had incurred.
But Ricky tells you how to do it. It gives you just the absolute out.
It does, Judge. It does. It tells you how to do that.
And says, I've spent all this money, Judge. I want a new trial. I want a mistrial, but you see how much money I've spent. Won't you hold it in reserve ruling on it?
Yes, sir.
It's a great benefit to the parties.
But Ed Ricky talks about. We would respectfully submit that the objections that in a sense it would have perhaps been preferable to do that, but it's almost elevating form over substance, because by objecting, which trial counsel did. He satisfied the 4 considerations that Ed Ricky talked about. and that is objections can deter opposing counsel misconduct. Objections prevent counsel from engaging in sandbagging tactics. Objections provide the trial judge with the optimal opportunity to stop it, and objections help prevent confusion that can stem from appellate court making cold record decisions. But their argument, and what Your Honor just alluded to as well, it's a wait-and-see attitude. So I guess the issue is, in this circumstance, who should be entitled to the benefit of a wait-and-see approach? And we would submit it's the aggrieved party. And
but isn't it really to put the thing is it put the Ed Rieke case puts then the decision, and I think Justice Kennedy said it earlier, I just want to ask you your view on it, in the discretion of the judge, so that the judge goes, you know what, no, I think this is not a case that can be fairly submitted to the jury. It's just has been corrupted by the conduct.
Right.
And I respect what you're saying, but in my view, this has now reached the point that it cannot be remedied. So the judge then makes that decision. The defense or the plaintiff then can't just be silent on it, or else the Ed Rieke thing means nothing.
Well, first of all, if the court reaches a point where the trial judge is saying to himself or herself, well, you know, this is a waste of time from now on in, and if it's a circumstance where he wouldn't reserve ruling, a trial judge could always mistry the case sua sponte. But the interesting thing that I wanted to point out about Ed Rieke, because it sort of talks about this case, granted, that procedure was not followed here. The record's clear on that. The moving for mistrial and then asking the court to reserve was not followed here. But as this court noted, that there's always a chance the judge will say, I'm not going to reserve, I'm going to grant it. And then you have the problem that the Ed Rieke court pointed out. And he says, if the mistrial were granted, the aggrieved party would have little solace, but the afforded remedy of trying the case all over again. So again, I think the question comes down to, given that counsel did object, the issue is, do you hold that lawyer to the same standard as in the Murphy case to a lawyer who said nothing at the motion for mistrial case?
All right, now I would like for you to address it, because that's what I was asking Mr. Eaton. It seems to me that, again, and I want to be careful that we don't, when we use fundamental error, that we don't harm the law as it relates to a defendant and his or her due process rights, because we do use the standard that it's cumulative and so pervasive that their right to a fair trial was impaired. That really is the standard, and it reaches down to the validity of the verdict for fundamental error in a criminal case.
Right.
Murphy took and has, as was mentioned, the 4 prongs, and the 4th prong is that it has the effect of undermining the public's confidence in the judicial system. Now, so my question to you is, if we agree that this is different than Murphy in terms of fundamental error, because objections were made and sustained, but it's not, you shouldn't get the benefit of it just being just the same as a new trial. Have you considered whether there is, in these situations, some other standard that a trial judge could follow in granting a new trial, knowing the tremendous leeway they have in so many other situations for granting a new trial? Have you, because I'm at a loss to say, you know, that's fundamental error, saying it's pervasive and it undermines their right to the fair trial. I know why Murphy did what it did, because somebody just can't sit by for the whole trial and not object. So now you have your situation. So, well, we did object. What's the reason for not you're saying it should be treated just the same as if they had moved for a mistrial. I think that's a hard sell. So is there another standard that would recognize a judge's greater discretion than a appellate court when these situations occur, but not the same as Murphy? And I don't know what it would be, but no one's proposed it, and so maybe you haven't thought about it.
Well, I have thought about it, Judge, and I think it's the deprivation of a fair trial standard.
But that's what the standard is under for...
For a mistrial?
For a mistrial.
Judge, I'm not sure about that because, or Justice, I'm sorry. I'm not sure about that because I think if you look at the case law, there's all kinds of different permutations. And sometimes you're just not going to be able, especially if the trial hasn't reached towards its end, you don't know whether a fair trial is going to be deprived or not because you haven't gotten far along enough. There's some cases that talk about, instead of this deprivation of a fair trial, that if certain comments are prejudicial and inflammatory. In other words, I think a judge on a motion for mistrial would probably have greater latitude than determining whether there's been a deprivation of fair trial, because a lot of times, especially if the misconduct occurs early on, you're not going to be able to tell whether the fair trial's been deprived or not. In fact, that's the whole problem with this case. You're dealing with a situation with cumulative misconduct. So it seems to me that once you reach what used to be before Murphy, a definition of fundamental error, and that is if you were deprived of a fair trial, it seems to me that certainly if counsel is diligent, at least in objecting, and at least giving the trial judge a chance to do what he needs to do in that instance, that to be held to a higher standard, that puts something above deprivation of fair trial, it just doesn't seem to be consistent with what's trying to be achieved. And let me say this, and I know opposing counsel's taken umbrage at some of the things that are in the record, but they're there, and even if they weren't admitted into evidence, they're a matter of public record. It's difficult to imagine a circumstance getting to the issue about undermining the confidence in the judiciary, where you already have a finding that the city was deprived of a fair trial, where the city is exposed to a judgment in excess of $17 million and actually having to pay that if there's a claims bill that's passed, and you have the other factors regarding the legal problems of counsel below. You have Mr. Camponi's trial counsel, second DCA counsel, interjected himself into the motion for new trial proceedings. The fact that one juror said, I wanted to give $50 million, but I thought the judge would reduce it. You have all these factors showing that this verdict was a result of anything but an impassioned consideration of the evidence. It's difficult to envision if you're going to have this other standard, this standard about undermining confidence in the judiciary, where you have a public defendant. It's difficult to envision a circumstance where that would be more in play than here. The second DCA didn't expressly deal with that because it believed it didn't need to, because it felt the objections, as a result of the objections, the deprivation of fair trial did it alone. But we would submit that even if that standard applies, that the record here shows that standard was met under either a de novo or abuse of discretion standard. And again, I remind the court respectfully that the only basis that Judge Bauman gave for that standard not being met is his feeling that the evidence was sufficient. And I would submit that is not logically coherent, because if you have to find, in order to get to that standard, if you have to find that there was insufficient evidence, well, insufficient evidence is an independent basis for a new trial anyhow, and you would have no need for that standard.
But I'm having trouble conceptualizing some of this, because it just seems to me that if the public knows that things have happened in a trial that have impaired or deprived a litigant in the trial of a right to a fair trial, that almost by definition undermines their confidence in the system, because that shouldn't happen.
Yes, sir.
So I'm having trouble understanding those distinctions.
Your Honor, I agree with you 1,000%, but that's the standard that was articulated in Murphy, the distinction. But I agree that once you have, and here of course not only you have an order of record that says that, it's difficult to imagine what more you need to impair the confidence in the judiciary than allowing a verdict to stand where a party was deprived of a fair trial. And nobody's disputing that. The petitioner hasn't taken issue with that finding in this proceeding. So, Your Honor, I would agree with that.
Murphy tells you what those are: racial, suggestions, religious suggestions. It tells you, doesn't it?
It gives some examples, yes, sir.
It does, and it's not a question of just pure sufficiency of the evidence. That's a different case.
That's true, Judge.
And that's what Murphy says.
Murphy gives some different examples, but the only basis that Judge Bauman gave here was he felt it didn't undermine the sufficiency because there was sufficient evidence. He links those two together.
Well, again, that's what I'm saying, is that if there's evidence, it's these things that create the emotion. And we don't have, I mean, tell me if we do. Do we have things such as racial things, such as religious things, such as gender things, things that are repugnant to our system of constitutional democracy?
We don't have those things in the comments themselves, but we have, and I believe that you would look at the context of the whole case, although Murphy is not explicit on that. But you have all these other things that happen. You have the assertion about what one of the jurors said. You had the fact that it's in the record that despite what Mr. Camponi testified to, that he had a checkered driving history.
Those aren't the kinds of things that's referring to. Murphy says that.
Well, no, Murphy doesn't. But I'm saying if you compile all of them together, Your Honor, that would.
What I would like you to do is to have the opportunity to explain to us, as we gave to your opposition, the analysis with regard to having a trial judge on a motion for a new trial having more power than an appellate court.
Yes, sir.
Because I'm not sure you've addressed that.
No, I haven't.
Specific.
I haven't, Your Honor.
And how does this fit into our system of jurisprudence?
It fits in exactly because Murphy did that. Murphy did exactly that. Murphy it gave the trial judge greater authority. It said if there are no objections whatsoever, the trial court could still review the misconduct on a motion for new trial on this heightened fundamental error standard. But the appellate court cannot do so, cannot be the first to do so. And Your Honor, it sort of sounds nice when opposing counsel says it, but if you look at it, that's been long established that it's not a matter of any disparagement of the higher court. It's a matter of the fact that the trial judge is in the position to look at the conduct and weigh it in the first instance.
Your time has now expired. Go ahead for another 30 seconds and wind it up, if you would.
Yes, Your Honor. Well, I mean, that's the point that I think that Murphy itself recognizes the fact, and other cases do well, but Murphy, this court recognized that in instances involving the trial court exercising his observation of the trial, that in fact the trial court does have some broader authority.
Thank you.
Thank you.
An appellate court has always had the ability to reverse for fundamental error, still does. The only thing that Murphy did was say as a prerequisite to an appellate court making a fundamental error determination, the trial judge has to entertain a motion for new trial asserting fundamental error, preserve the issue that way. That's all. Murphy does not give trial courts greater authority than an appellate court has to grant a new trial for fundamental error. It simply doesn't. The answer
but ordinarily, fundamental error is something that can be raised on appeal without having been raised in the trial court, correct?
It always was before Murphy. I'm not sure that's true after Murphy. Murphy says as a condition proceeding
Well, again, let's just make sure in a civil case, because we certainly don't want to put the two standards in, I mean, there's different values and considerations.
Although I suspect the case will come along in which a court is sufficiently aggravated at what happened in a civil case, that it will find fundamental error without a motion for a new trial having been filed before the trial court. But that's kind of an unanswered question at this point, post-Murphy. The answer to your question, Chief Justice Kennedy, is if a litigant is deprived of a fair trial because reversible error has been committed, he gets a new trial. But it's an altogether different standard, fundamental error, than simply having committed a reversible error. Now, the bottom line here...
Your time is now up to, you can have another 30 seconds.
The bottom line here is that counsel did not want a motion for mistrial. He did not want a mistrial. He said, I'm content to go to the jury on this record, and then he lost. And he said, oh, by the way, I want a mistrial. You can't permit that. The cases don't permit that. The district court's opinion is simply wrong, and we respectfully request that this judgment be reinstated on remand. Thank you.
Thank you very much. court will now take its morning recess for 10 minutes.
Please rise. and gentlemen, the Florida Supreme Court. Please be seated.
May it please the court, my name is Joel Eaton. This time I represent Mr. and Mrs. William Cox in a medical malpractice action against St. Joseph's Hospital and Dr. Eric Castellucci. Mr. Cox had a stroke. He was delivered to the emergency room at the hospital within minutes of the stroke. Nobody at the hospital bothered to find out the time of onset of the stroke, although there were several people in the waiting room that knew.
I have a question on the issues in this case. If, and it has to do with this issue of, or non-issue, however you look at it, the subdural hematoma. Does the question of whether TPA should have been given in light of the subdural hematoma that he may have, that he sustained several years before, does that go to standard of care or to causation? To me, it seems more of a standard of care issue, which isn't before us. So is that something you're prepared to discuss? In other words, the role of the subdural hematoma, if any, in what the trial court and then what the jury and then the second district decided?
I don't think the issue of whether there had been a subdural hematoma in the past or not has a thing to do with the question that was decided by the district court. It was their principal defense at the trial. If we had known about the subdural hematoma, which we didn't because we never bothered to ask anybody, then we wouldn't have administered TPA.
Okay, so that issue then is really would go to the standard of care. Now on causation, does the issue of whether you on behalf of the plaintiffs met the standard of more probable than not turn, and let's not talk about Dr. Burge, but essentially turn on Dr. Futrell's testimony?
Yes, although Dr. Burgess did say that based on the information I had at the time, I would have given her.
Well, it was a letter. I'm concerned about that opinion and the separate issues about that. So just let's on Futrell. Futrell bases her testimony that it was a high probability that he would have had a minimal deficit to a full recovery if TPA had been given. She bases that on her examination of the CAT scan, primarily, that was given right after he was admitted, and the excellent condition of the neurological condition or the brain structure. Was that the fact the second district doesn't mention all of her testimony about why she thought he'd have such a good chance of an excellent recovery. How do we deal with that here in a conflict issue? In other words, if she hadn't talked about that and just said there was a high probability and really didn't give any reason, be one thing, but she did. And so, but I'm trying to figure out from a conflict point of view how we deal with that.
Well, there are at least 4 separate kinds of conflicts here, so take your pick if you need a jurisdictional foundation. But the answer to your specific question is, Whale versus Barnes says if there's expert testimony, medical testimony, on the issue of causation, that's direct evidence sufficient to defeat a motion for directed verdict.
But do you agree that, maybe you don't, but I'm concerned that I wouldn't want to come out with an opinion that said, if a plaintiff says after asking all these questions in a complicated case that, and do you have an opinion more probably than not whether the person would have survived? Yes, I think within a high probability. They got to give factual basis for their opinion at some point. They may not have to give it on direct examination, but can a plaintiff just simply say there's a high probability without there being any facts that would support that opinion?
Well, you're getting way ahead of my outline, but Section 90.705 says precisely that. Now, 50 years ago, in the case that the Second District relied on, an appellate court would require all the underlying facts of an opinion, but then the evidence code was amended a quarter century ago, and 90.705 now says that an expert can give his opinion without giving the basis for the opinion.
But in this case, she didn't just do that, and I guess but the second district opinion makes it sound like she did, and I'm just,
Well,
I mean, don't you think I would think, and there's a friendly question, that her findings about the CAT scan are very significant to why she concluded that he would have been an excellent candidate for the TPA?
The second district said, we're not going to pay any attention to this expert testimony, notwithstanding Wales versus Barnes, for two reasons. One, Dr. Futrell's opinion, which clearly satisfied both Gooding and Whale versus Barnes, we're not going to pay any attention to it because her opinion is constrained by statistics. They took this decade-old test, study of a random sample of stroke patients to determine that less than 50% of them gained any benefit from TPA, and therefore they weren't going to accept Dr. Futrell's opinion that this individual would have had a beneficial effect from the drug.
Now, on the cross-examination, though, the study was never introduced in evidence, correct? This NIN study?
It was never in evidence.
It's not in evidence. She talks about that she acknowledges that the study could be that 20% of the patients made a complete recovery, and but then she says, but that's a distortion of what the results were, and she starts and talks about that the worst number was a 36% improvement. So again, let me ask you this way, if she had in fact said, I find this study authoritative, and that I agree that that's the number, and stop there, would there be a problem for the plaintiff?
If she had given an opinion that Mr. Cox's chances of a good recovery with TPA treatment were less than 50%.
No, if she didn't explain, if she acknowledged, yes, that's the case, but never explains why that study doesn't explain any problems with those numbers. I guess it seems to me once you've said that she acknowledges a study, that doesn't she have to further explain why those numbers are not what this 20% and then the 31%?
Your Honor, the study was of a random sample of stroke patients done during a drug trial for FDA approval. It was 10 years old. The study that they were reading to her was a different study, she said, that distorted the figures in the NIN study, which
that's
is
what
not
I'm asking. So she did go on. That's what I'm saying.
Yes.
That she explained some problems with those numbers that would therefore not be that she's constrained by statistical evidence.
Well, she also said there's an additional study out of Canada, and there was an objection. They said, oh, we get to rely on the NIN study, but you can't rely on the literature that supports your position. And I don't see that they can have it both ways. But the important point is that the study doesn't control Mr. Cox. Mr. Cox was an appropriate candidate and would have benefited from this therapy based on all the tests that the emergency room doctor ran for the benefit of the on-call neurologist who would use these tests, particularly the CT scan, to determine whether Mr. Cox was an appropriate candidate for therapy.
But let me ask you this way. When you're talking about a drug, a lot of times this might be in a cancer case, and an oncologist doesn't find the cancer, say 5 months or 6 months earlier. And then the issue is, would it have made a difference? And the oncologist they're constrained by, the only thing they can do is give drugs, treatments, or radiation. So they go, well, if they had been given this drug several months before, it would have made a difference. But all the studies on the drug show that something else. Does it, in a situation where they're talking about whether a drug would have made a difference as opposed to the forceps delivery and I think whether that was Wales, is there something else that that you are constrained by as a medical expert because you are only as good as what you understand the studies to say, whether to give a drug or not to give a drug? It's not like something you can just experiment with and say, I think I'll try this drug or that drug. You've got to rely on the studies. And I'm concerned about that, I guess.
I think it's considerably more complicated than that, because each patient is different, and a drug can help some people and hurt other people. In this particular case, this drug can help some people and hurt other people and doesn't work on a middle group, and you got to do it within the first 3 hours.
But so ultimately, there's an element here of experience.
Experience and training.
With the use of the drug and the experience and training of the physician who would be called on to consider administering it, or the experience and training of the expert physician who's rendering an opinion about whether it should have been given or not given, and what difference it would have made if it had been given, right?
Yes, Your Honor.
I mean, it's a matter of experience and training of the expert.
But the point is that this study doesn't say never give this drug to anybody. It says this drug can be very helpful to 31% of the people who are the right candidates for it. Mr. Cox was the right candidate for this drug. And curiously, the defense experts didn't testify that the drug wouldn't have helped him. Their testimony was it's impossible to know.
There's no suggestion that from the study or elsewhere that the effectiveness of the drug is random, is there?
No, Your Honor. It depends on the condition of the brain and the vascular system and where the clot is and prior history, and that's why you have to have an expert to analyze these things, because I certainly couldn't tell you whether this patient was an appropriate candidate and whether he would benefit from it, and neither can any of you, and neither could the 3 judges that heard this case below and decided that this woman, who is an internationally recognized stroke expert, didn't know what she was talking about. That's why I'm up here complaining. Wales versus Barnes says her testimony was direct evidence on the issue of causation, and which prevented a directed verdict. And you can't say, but her testimony is constrained by statistics, and because the random sample shows that less than 50% are going to benefit, nobody can win. But
wasn't her testimony that for this category of of a patient, that it would be high, it would not be the 30%. He would be above 50% on this, because the study was showing people that also had other problems. I mean, I guess I thought that's really how she was distinguishing the study.
Correct, Your Honor. Now, you can't take a set of statistics and constrain an expert's testimony and say, because the studies show less than 50%, this expert's opinion of greater than 50%, we have to discount.
Well, is it important that she doesn't really acknowledge the NIN study as being authoritative? In other words, it seems to me that there is the basic premise that she acknowledged the study and that it was binding doesn't come from her actual testimony.
I don't think she acknowledges it was authoritative at all. She said the study you're reading from is a distortion of the NIN study. That's what she said. The NIN study was never put in evidence.
Do we know what study they were reading from? I mean, this is sort of hard to follow in the record.
It's not in evidence either, and I don't know the answer to that. And of course, when Dr. Futrell tried to say there's an additional study that I rely on, they objected, and the objection was sustained, and they're saying we can rely on one study, but you can't rely on the other study. The whole thing doesn't make an awful lot of sense to me. By the logic of the district court, the fact that this court takes less than 5%, 10%, I don't know what the number of the cases that you take on discretionary review are, that should discourage me from ever trying to come up here. By the district court's logic, I will always lose. But I'm here. Mr. Cox.
Well, that's not, I mean, maybe
that's
you actually
logic.
have a better chance of winning, right, if you're coming up here as the petitioner, because we've decided to accept the case. But what the second district is saying is that she didn't adequately explain why he would be in this 31% or 21%. That's really, isn't that what they ended up, that's what their opinion says?
Well, they had 2 bases. The first one was her opinion is, all these cases that follow Whale versus Barnes were not constrained by statistics, and therefore we don't have to follow Whale versus Barnes. They misapprehended and misapplied the Gooding case. I'll skip that because that's fairly obvious. Then they went on, the second ground was her opinions were speculative as unsupported by sufficient facts. Now, they didn't say what facts she didn't supply, what facts she should have supplied. What she did was examine the very tests that the emergency room did to determine whether they should supply TPA therapy to Mr. Cox. Those tests were the decision makers for the neurologist. She looked at them.
Mr. Eaton, you're now in your rebuttal time.
I'm always in my rebuttal time. She looked at those tests.
We help you do that, I understand.
And said, this man is an appropriate candidate and he would have benefited. What else could she have done? And besides, as I mentioned earlier, 90.705 says her opinion could come in without any facts at all, and this court said that in Jackson versus State in 1994, there is no requirement that the facts or data underlying an expert opinion be admitted into evidence in order to establish the basis of the opinion.
Well, since you brought that up again, I've read 90.705, and it says there on cross-examination, the expert shall be required to specify the facts or data.
If she wasn't cross-examined on them, she was cross-examined on the NIN study. All her testimony about the test came out on direct.
I'm talking about how that interacts with this particular case is one question. But the notion that an expert can just come up there and give an ipsy-dixit, and if challenged on it, can just say, well, that's what I think, and that's it, is, I think, very questionable in light of the actual text of the
I'm not suggesting that at all, Your Honor. They're entitled to cross-examine her on the basis of her opinion, but she gave it on direct examination. Two quick items. Atkins versus Hume says the reason expert testimony was required in this case is that laypersons and judges don't have the medical expertise to make decisions like this on standard of care, breach, causation. You got to have expert testimony, but 3 judges with no medical training at all below said, we don't buy this expert's testimony, defendant wins, and that's just not correct. There's also a line of cases that say the sufficiency of the facts is for the expert to decide, not for the judiciary, because we don't have any medical expertise. This woman's opinion is plainly enough to support a jury finding of liability and causation in this case, and the district court is simply wrong, and we respectfully request that it be reversed. Thank you.
May it please the court, my name is Kimberly Ashby. I represent St. Joseph's Hospital, one of the respondents, and we've agreed to split our time today at oral argument in half, so I'll have 10 minutes. The second DCA, the second district, did not create a conflict for jurisdiction in this court when it issued the opinion in this case. The TPA therapy is a clot-busting therapy for stroke victims that is manufactured by Genentech. Genentech and the FDA have issued a report that shows that there is a 31% chance that the TPA therapy is going to have a beneficial effect on the people getting it, with somewhere in the neighborhood of 20% of that population.
Do you rely, the study didn't come into evidence?
Correct.
Would you suggest that this court is able to go on the internet, and should we separately look at the study?
I would have absolutely no objection
Well, I
to
mean,
that.
but is that something that an appellate court should be doing?
I think some of the other courts that I cited to this court that have looked at the TPA therapy delved into the study itself more in depth because it looked like it was
But to try, I mean, Frank, I will say, I've tried to look at these things on the internet without experts explaining it. I don't know how I don't think it's at all something that's somebody's capable of looking at. Did your experts, everybody focuses on Futrell's testimony in Cross, where I don't think she admits the authoritativeness or the numbers that you're talking about. I didn't see any citations in the brief. This was a very lengthy trial. There were a lot of experts to testimony from your defendant's experts that clearly explain why he wouldn't be why the 20% or the 31%. Is that in this record, and did you cite to it in your brief?
We did not cite to the testimony of the defense experts because the question that was before the second DCA and what was found in the opinion is whether the directed verdict was appropriate.
Okay, so if we don't agree in looking at what Dr. Futrell said, that she acknowledged that study as authoritative or agreed to the numbers as being applicable to him, then there is no basis for the second district's statement that they're constrained and she was constrained by statistics. That's where I'm having my problem.
Understood. And if I can address that, I think that what the second district said is that you can't just say something and make it so. And what she said in order to say, I've taken the 31% and I am bending that number because she did recognize it as the study number, and whether you want to go to the extreme of saying she recognizes it as authoritative or not, she does make reference to it as the study. And then she says that she's capable of picking out somewhere on the order of 100% of the people that are going to fall in that 31% category, which really puts statistics on its head when you do that. The reason
I don't quite understand that, because I can understand the statistics, but I don't understand that those statistics indicate that the effectiveness of the drug is going to be random. And it seems to me that it makes a perfect sense that someone who's experienced in the use of it might be able to look at the particular circumstances involved, the particular characteristics of the patient, and whatever else would be relevant to the effectiveness, and make a judgment that there's more likely than not to work for this patient, and they're not constrained by a study which again, unless the scientific indication would be that we don't know when it works. It is just random, but there's nothing in the record that indicates that the effectiveness of this drug is random, is there?
Well, no, there isn't a finding one way or the other of whether the effects are random. But more to your point, what Dr. Futrell said, I can pick patients such as Mr. Cox out and testify that he is in particular good stead with this therapy, when her clinical, the rest of the background for her, the underpinning and basis for her being able to say that is not there. That is the missing table leg.
What more does she need than if she were the treating physician at the site, having all the studies and having the information that in her opinion, that's what experts do, that more likely than not, and I haven't seen many experts voice it a very high probability. Most of them are within a reasonable medical probability, but this was expressed very highly, that he would have, whatever, that his chances or what was going to happen to him was going to be a beneficial result. I thought that's what she said.
Justice Lewis, if you look at what she claimed, and I have all the respect in the world for Dr. Futrell, I'm not trying to make this a personal thing, but if you look at what she said as far as her clinical experience, because otherwise she's just relying on the medical literature, and that's what we were talking about.
Are you then, if you're saying look at her clinical experience, that she's not a qualified expert?
No, I'm not saying that, because if she's got expertise in strokes, then sitting in the witness chair, is she, generally speaking, qualified to talk about stroke issues? That may be yes, or that may be no. If she's ready
I didn't understand this case being one as that she was not qualified to express an opinion.
And I'm not suggesting that it is.
Well, that's what you're saying to me.
But I'm really focusing on the opinion itself, not the opinion giver and her qualifications to give opinions, generally speaking. But if you look at what she uses as her clinical experience to support this opinion, she said, I have 40, 50 patients. We don't know what happened to them. We don't know whether any of them had any of the demographics at all that match up with what Mr. Cox had. Because when she talks about, and Justice Pariente is concerned about her, she's looked at the CT scan, this is after the stroke, and she finds that for a man his age, his brain looks relatively young, because we would expect to see more shrinkage fine. Where is the evidence that shows I have clinical experience with younger than expected brains?
Okay.
And here's
then what you're saying is,
on
okay, that every expert then will need to come in any type of situation where the expert's testifying based upon training, experience, work in the field, and explain every one of their patients or every one of the buildings that they've done or every professional action that they've taken, to support their opinion. Is that what you're suggesting?
Not entirely, but
But-
if they
but
have
something
no,
like that.
If they have no basis, though, then it is.
Well, it's easy to say no basis, but I mean, that seems to me to go into the qualifications. If you felt that her 40 to 50 was not sufficient, then somebody needs to challenge that.
And that's what was done. And
Well, I
it
don't
was
read
done,
the-
it
I
was
don't-
done as a calibration of whether we have sufficient competent evidence to go to the jury on causation in this case.
If it's not qualification, why wouldn't it at least be a credibility issue as to which expert you choose to believe and therefore be a jury issue? Isn't that up to the jury to decide which expert's more credible and which ones they believe?
If this was just your expert says X and my expert says Y, I would agree with you. The reason that doesn't apply here is because of the nature of this drug. As Joseph Pariente points out, this is not a procedure, or I've used the forceps wrong. This is a drug that has been tested. And this expert recognized that test and said, but here's why I can pick the better population out of that 31% in order to put me over the bar on the 50% or more likely than not.
But you're using, let me go back to the percentages. She, on direct, said why she thought he had a high probability of making an excellent recovery, and based on the CAT scan and everything she has. I mean, this is, again, not only an expert whose qualifications were in challenge, but a very, very, not, I mean, whether she gave 40 to 50 patients TPA, she has reviewed hundreds of CAT scans. And what she says on the cross-examination that you rely on and that the Second District relies on is that, first she says the subsequent paper was a distortion of the NINS study, and then the question is, but you said it's not a distortion. The study said that 20% make the kind of recovery without any medication. The number goes up to 31%. That's what it said. She says, it said that, yes. And you know, if you do the mathematical calculation, that means you got to give this medication to 8 people to get one that makes the kind of recovery you say Mr. Cox is going to get. Isn't that true? No, that's not true. Why isn't it? Well, first of all, the categories Mr. Cox would go into either of the two, and then she goes on, and then she says the worst number in the NINS study, that there was a 30% improvement, or 36%, were for people with all problems. And so you're quoting a paper that later looked at the data and said it wasn't that good. So my first problem with what the Second District did is it seems that it misstated what she says about the NINS study. And since we don't have the NINS study in evidence and we don't have anything else saying it's authoritative, and I'm not sure how we go out and look at a study and then, make some conclusory statements, I think that's where the problem is. So please help me with that, whether we just go and do what the Second District said. They just accepted this 20% and 31% figure when she didn't acknowledge that that is an accurate statement as to all people like Mr. Cox.
I think
you're now in your co-counsel's time.
With
I
my
understand.
1-minute
So,
question.
I will give y'all a little more time, but I need to wrap it up.
So I'm concerned about the cross-examination and that figure.
And Your Honor, the expert, Dr. Futrell, used the study as her platform. She could have jettisoned it and said, the study is old, I don't rely on it, it has no purpose here. She said, here's why I can pick the population out of that group, and that's what makes her opinion unfounded in any other clinical or legitimate experience that's found in the evidence code, and that's getting to her saying it, making it so. We did ask the court to, I did bring up the other issues that we had raised at the Second District that were not addressed in the opinion, and I would be remiss if I didn't point out that we still consider those to be unresolved at this time. Thank you very much.
May it please the court, Irene Porter on behalf of Dr. Castellucci. I'd like to address the cross-examination of Futrell. She was asked, is the NINS study the one that established the efficacy of the drug? And she agreed with that. And she agreed with the statistics. What she then went on to talk about is a second study and whether that meant 1 in 8 wouldn't work. And that's what she said was a distortion. That was a subsequent analysis. She did never, ever, ever disputed the NIN study. And the other problem that we have, and the reason...
But again, the NIN study, correct me if I'm wrong, but it does not establish that the effectiveness of the drug is random, does it?
I believe that it does. The testimony I wrote down, I went back while you were talking and looked what else we had in the record. The defense expert, Bernstein, testified in 1831 to 1833 of the trial transcript about the NIN study. My understanding of that testimony is that it is just an overall random effective rate. 20% improved getting a placebo, 31% improved getting the drug.
Well, but it's one thing, I mean, I guess I don't follow that, because it's one thing to say, here, we gave this drug to this population, and we did the control, and here are the results. It's another thing to say that nobody can figure out why it worked with some people and not with other people, or why it was more effective with some than with others. That's an entirely different question.
I understand that question, and the problem with this particular case is we didn't even get there, and we don't need to get there, because Mr. Cox undisputedly had a prior subdural. Whether this drug can ever work, in his case, has never, ever, ever been tested. Everybody concedes that, and Dr. Futrell has never given the drug on that type of patient. This is exactly like the cancer thing. I've got cancer, doctor, what can you do for me? We've got a clinical study. I think you'll benefit. I can't really tell you because I've never studied it.
My problem with this is that when I look at the second district opinion, instead of the second district, in my opinion, looking at whether or not a directed verdict should have been granted or not, they seem to be putting themselves in the position of the jury here and discounting or accepting some portions of the evidence and not accepting other portions of the evidence. And so that's what my real problem here is. Doesn't it look like the second district is actually acting as a jury in this case?
I think that the opinion may be confusing. It talks about the fact that he had a prior subdural, and then it goes on, and then it talks about studies. I think the bottom line, though, is that the result is absolutely correct for two reasons. One, they didn't even reach that he couldn't have ever gotten the drug, or would not have in this case. But if we look at the subdural...
Was that issue actually...
That was briefed and that was argued, and the petitioner... But they didn't discuss
They didn't discuss it.
Oh, I'm sorry, the subdural. Yeah, the subdural being there. The only thing Dr. Futrell said is, I don't think it was really significant because he didn't have any resulting brain damage. She never denied that it existed. She said, I asked you to go out and get me the scans, plaintiff's attorney. They don't exist. All right, I'm going with the records.
All right, and she also says that a neurologist who has experience uses their clinical judgment, and she said giving TPA would not be an absolute contraindication because whatever there was resolved within a short time, and the CAT scan on that morning was a perfectly normal CAT scan with no evidence of any, not just any brain damage, of any prior subdural hematoma.
Well, or any current intracranial hemorrhage, no current. That's another contraindication. She didn't say a subdural that's resolved will show on a CT scan, and we had testimony from both Dr. Burgess and Dr. Crisp, the Canadian doctor, the neurologist, that what these hematomas do is they weaken the blood vessels. Now, that doesn't show up on a CT scan, but the CT scan goes to one thing. Can you have the drug? If you've got active bleeding, no way. She even agreed with that. But she says, I don't think I don't think it's that bad. You can still give it. Other experts said, absolutely not. Dr. Burgess said, absolutely not. And Dr. Futrell and plaintiff's other expert admitted, look, if you want to follow the guidelines and not give it, that's perfectly appropriate, that's reasonable, that's within the standard of care.
But this isn't a standard of care. We're not here on a standard of care case.
Standard of care comes in on the second issue that the second district didn't discuss and reach, and that is our causation argument that what we should have done, they say, is find out when the onset of the stroke was. Therefore, I would have gotten a drug, and therefore, I would have gotten better. Point one, you have to say, I would have gotten the drug. How do you prove you would have gotten the drug? The neurologist who's on call would have had to have given it to you. And that's why they went out and got a letter without giving him all the facts to try and prove that. That ended up not based on the facts. He says, I would not give it. I consider the contraindications absolute. I wouldn't even think about it. So
this is
that's,
so the neurologist who was never called in until after, who never inquired about any history of subdural hematoma, and said that he couldn't be given TPA because it was after the window, and that doctor had since been sued and was on staff. You're saying because that doctor said I wouldn't have given it to the patient, that goes to
it goes
what?
to causation. The only reason standard of care comes into it, if I may explain, is we relied on Ewing versus Salinger, that if your theory is Dr. A was negligent because had they done something, somebody else would have done something different. If you get Dr. B, the subsequent treater, and say, no, I wouldn't have changed my course of treatment, there is no causation. The only...
And you're saying that even though that the expert can supply that, yes, a reasonable doctor looking at it would have given it because a subsequent doctor says...
The reason standard of care and reasonableness...
Can I finish? You're saying that an expert can't supply that testimony on standard of care?
Experts can supply the testimony on standard of care, but when you have the actual on-call doctor and he says what he would have done, it has to be taken as true unless there is evidence that that doctor would have been negligent in saying he wouldn't give it. That's the only reason standard of care comes into it. And that's...
Well, this is complicated because we've got different standards of care here. The standard of care that the defendants here were accused of breaching is the standard of care related to making a proper inquiry about when the onset of the stroke.
Correct.
And then we got a different standard
Correct.
of care that applies to when the drug would be administered or not. So
correct. And that comes in with the causation. And I didn't mean to complicate it, but the reason it becomes important is we rely on Ewing versus Salinger that says if the on-call physician says, I wouldn't have done what you said would have happened, end of story, no causation. The 3rd District and the 5th have come back and said, well, we don't agree with that if it means the subsequent treater could have also been negligent and you can't have causation. So that's why I'm discussing standard of care. Dr. Burgess said, I would have never given it. Dr. Futrell said that's a reasonable, not below the standard of care thing for Dr. Burgess to do.
You're into your time. I'll give you another 60 seconds.
And, well, in conclusion, we think we could win, we should win, and on directed verdict on 2 grounds. 1, he would have not ever gotten the drug, which the 2nd District didn't reach, but you can reach. And 2, we believe it's utterly speculative to rely on studies that don't include a patient with this contraindication because you cannot prove a dangerous drug is going to improve someone when it's never been studied. Thank you.
Thank you.
There was no objection to Dr. Futrell's testimony or her qualifications, and in point of fact, the defendants never moved for a directed verdict on the ground that the district court said they were entitled to a directed verdict on. This therapy is given to patients. The drug is effective in some patients. It is a question of medical judgment which patients get this drug and which patients don't. And this internationally recognized stroke expert said this was an appropriate patient for treatment.
What about this issue on this Ewing versus Salinger?
That I will address. Ewing has been disavowed by one member of the panel that wrote it, that participated in it. That case is cited in the brief. It has been disagreed with by the 3rd District in a wonderful, beautiful opinion by Judge Schwartz in the Munoz versus South Miami Hospital case, and there's a second one, the Stay Right Industries case. The 5th District has disagreed with Ewing versus Salinger in the Goolsby case and another case. I discussed those in my reply brief. Ewing is no longer considered good law anywhere in the state except perhaps in the 4th District. But I don't think you're going to need to get to that because this prior subdural hematoma thing is a red herring. It was their defense. It depended on what I have called the 3 ifs and a maybe defense. It depended on the jury assuming what might have happened if 3 different things that didn't happen would have happened. The jury rejected it. Dr. Futrell said there is no evidence that this man ever had a prior subdural hematoma, and from his CT scan, it made no difference to my opinion in this case.
What about her point that he never would have gotten the drug?
Their argument was, because we discovered during the course of this litigation something that we never asked anybody about at the time, that this patient may have had a prior subdural hematoma, that's an absolute contraindication for giving this drug, and therefore Dr. Burgess, who recanted his former opinion, said, I would never have given it because he had a prior subdural hematoma. Well, the evidence was that this was not an absolute contraindication, that this was merely a guideline. That came from their own experts, that in fact there was no subdural hematoma on a prior occasion. There were 2 MRIs, one of which, reports of MRIs, one of which showed a hematoma, one of which did not, taken 6 weeks later. There was all kind of evidence that refuted their subdural hematoma theory. And the jury bought our version of the facts, not their version of the facts. And what's been argued here today and in the briefs is a jury argument on their defense that the jury rejected. And I will close by reminding everybody here once again that none of us know a thing about the medicine in this case. That's why we have experts. And it boggles my mind that 3 judges, as wonderful as they are and as bright as they are and as good lawyers as they are, can say we don't accept the medical testimony in this case because we know better. That can't be the law. Thank you very much.
Thank you very much.
All right, on the last case this morning, Justice Kennedy is recused. I call the case of Board of County Commissioners of Collier County versus Dwight Brock. Ms. Hubbard? Yes, and I understand, just so we make sure, you're going to take 10 minutes. You give Mr. Stewart 5 minutes, and you want to save. So, is that correct?
Yes, 5 for rebuttal.
So you start with, we should start with 15 minutes then. Okay, so I'm going to, so that you understand, if you go all 15, you won't have a rebuttal. So I'll remind you at, are you doing it that way? Okay, we have 20 minutes, so 10 minutes, will a light go on at 10? Okay, so I'm going to tell you, I'll try to remember to tell you at 10. Okay, okay.
Okay, good morning to all of you. I'm Jacqueline Hubbard, Litigation Section Chief for the Collier County Attorney's Office, and I represent the Collier County Board of County Commissioners. There are a couple of points that I think are important to make in this case. One of them is, I believe that the legislature knew what it was doing when it drafted certain statutes that pertain to the issue we have today. When I when I refer to a rule, I mean the rules of the Florida Auditor General.
The Florida what?
Auditor General. And these rules were promulgated by the state legislature. And under this rule and other statutory provisions, all county audits are to be conducted under the rules of the Auditor General.
But does that mean, because under the Constitution, the clerk is an auditor?
The clerk is an auditor under the Constitution.
So why wouldn't, and I'm going, you know, this is not an area I'm familiar with very intimately, but we have, of course, inspector generals here at the court. An auditor can, but an auditor, can an auditor not do investigations and to determine and, you know, look at make sure there are controls in place, and that kind of generally accepted, not a financial audit, but to ensure that the finances are being properly accounted for, and that there are good procedures in place.
Well, let me just say this. The reason why I initially referred to the rules of the Auditor General is because the state legislature gave the Auditor General, mandated that the Auditor General impose rules and regulations on how audits are to be conducted for local governments. Now, if you look at Article 2, Section 5C of the 1968 Constitution, it says the powers and duties, compensation and method of payment of state and county officers shall be fixed by law. It included the powers and the duties shall be fixed by law. Article 8, Section 1B said the care, custody, and method of dispersing county funds shall be provided by general law. Now, we have a whole series of general law that's been passed by the legislature that pertains to this. And yes, I would agree with you that the clerk has those statutory and constitutional titles. But that's all they are until they're filled in by statute.
Well, I mean, it's not only titles. They've got some duties and some liabilities.
Yes, they do, and so does the Board of County Commissioners. And the
well, that doesn't address what a clerk can or can't do, just because a board may have so. And on these rules, what about the prepayment internal audits? Are you saying they can't do those either?
No, that's not what I'm saying. What I am saying is that the only statutory provision that provides for some type of pre-audit, and I'm quoting Alachua County, is 12909. Now, I want
Which was changed after Alachua County.
No, 12909 has been in effect since 1971, and it is still in effect.
What was changed from 1977 to 1979?
What was changed was the words post-audit in Chapter 11 came into being. And in Chapter 11, the legislature defined the types of audits that can be done: financial audit, performance audit, operational audit.
And changed the basis upon which the Alachua County Court relied.
No, the Alachua County Court, in my opinion, relied upon the Alachua County Court, the initial target of that opinion was, what is the clerk's duties under 12909, not under some other statute. 12909 was the statute that was referred to in the case. And Alachua County held in that case that under 12909, even though there was nothing in the statutes that said the clerk must perform an audit, since the clerk has the authority and the duty and the ramifications of not doing it correctly, he has to do some kind of pre-audit function, which is the language that the Alachua County Court used.
A pre-audit function or a prepayment audit?
A pre-audit function, pre-audit. Now, that same statute, 12909, that places that responsibility on the clerk, also places the responsibility on the board in 12908. They're basically the same, except one places the responsibility on the board and one places the responsibility on the clerk, and that is you cannot sign a legal warrant or make an illegal payment.
Right. Well, why should this whole relationship not be determined on the basis that certainly the Board of County Commissioners retain the authority to have the certified financial audits conducted, but that does not in and of itself prohibit a clerk from conducting an internal, may I finish?
Oh, sorry.
To complete an internal audit.
Well, this is where the confusion comes from, because the Constitution does not say that the clerk is an internal auditor. Chapter 11 doesn't talk about external and internal auditors, but there are statutes.
How can a clerk be personally responsible, both civilly and criminally, if they do not have the ability to look internally to determine whether something has been paid correctly or is being paid correctly or is not?
Well, we don't really oppose the clerk. Let me make this clear.
Wait a minute, I need an answer to that question.
How does, your question again, sir? I'm sorry, Justice Lewis. How does he do what?
If a clerk
Yes,
has both criminal and civil liability for
Yes.
any improper payments,
correct.
how in the world can that position, the person in that position, be subject to that responsibility and liability if he or she, that office holder, is prohibited from looking at internal audits?
The clerk is not prohibited from looking at internal audits. Let me make myself clear here where the county stands. The Board of County Commissioners does not contest, number one, that the clerk is the custodian of all board funds. Number two, the board does not contest that the clerk may examine and inspect all of the funds in any board bank account. And he can do it as often as he wishes because the clerk has custody of the board's bank accounts. So of course he can look in there. Board funds are held in public depositories and are accounted for by the clerk as the board's accountant. The clerk to the board under 125.17 and the accountant to the board under 28.12, however, limit what the clerk can do. And here's what the clerk can do under those two statutes. Number one, the clerk can perform such other duties as provided by law. And if it's not provided by law, he can't do them. And two, perform such other duties as the board may direct.
And you're saying that all those together say that the clerk cannot conduct internal audits?
No, I did not say he can.
Well, that's my question.
He can conduct internal audits of his department, but that's not what he wants to do. He wants to come over and conduct internal audits.
He wants to conduct an internal audit of county funds.
No, he can. No. He can conduct any kind of audit of funds because he has the bank accounts. And 13608 clearly says that he has custody.
What's this dispute about?
The dispute is about this. The dispute is that historically the clerk has come over from his part where he resides as a constitutional officer over to the board side where they reside as constitutional officers, and without notice, without asking for permission, he has come over and gone to departments in the county, plopped himself into that department, and begun audits.
If that pertains to the expenditure of county funds for which that clerk is responsible, why can he or she not do that?
He can't do it because it is a...
Tell me where the provision that says that you can't do that.
Okay,
I'm sorry, I don't buy that.
let me give you the provisions
May I finish,
that say...
please? May I finish my question, please?
Yes.
I don't see how Alachua County addresses that, because Alachua County addresses post-audit, post-payment audit, and it deals with the issue with regard to the statute that you change the phraseology that would allow, whether it would allow independent auditors to come in or allow the clerk to come in. Doesn't it?
No, Your Honor. Unfortunately, I beg to differ with you. Alachua County, that case deals with the audit power of the clerk vis-a-vis the Board of County Commissioners, straightforwardly, I must say.
Ms. Hubbard, and please answer fully Justice Lewis's question. I just want to remind you, you've used
Yes.
now almost 11 minutes, and therefore you're in rebuttal
Okay, I'm
time.
almost in rebuttal, but let me just say, there's a series of cases from this very court that go all the way back to the turn of the last century that says consistently, from Landis v. Wheat to White v. Crandon to Mullen v. Turner to Gesner v. Del Air to Alachua County to Escambia v. Bell. Those cases from the Supreme Court say that the Constitution contemplates the clerk as ex officio auditor of the county, who shall audit all claims against the county that are presented for payment. but not perform other auditing duties unless so required by statute.
Let me talk to you about the statute for a minute. 136.08 says,
Yes.
a clerk's duties also shall include the inspection and examination of the accounts of each and every board and the county accounts of each and every depository.
That's correct, because under our system of government, which we do have a separation of powers here, under 136, it talks about the fact that board funds are held in public depositories. So all board money must be in public depositories.
When you read that sentence of the statute, is it your view that it only pertains to depositories or something in addition to that?
Well, I think it's entitled county depositories.
Well, it says the inspection and examination.
Yes.
Examination would also include a type of audit review, right?
Well, it says, let me put it this way. It definitely, 136.08 says that the Auditor General and the clerk may inspect and examine all bank accounts of the county.
Well, it says more than bank accounts. It says the accounts of each and every board and the county accounts of each and every depository. So when I read that, it seems to me what they're saying is accounts as in the term of in a general ledger, or the accounts that the county uses to account for its financial statements, not a presentation of financial statements, but the accounts of the board and the depository accounts. It says two separate things there, does it not?
It may, but it says that all county money will be in county depositories. And the only accounts handled by Collier County are already handled by the clerk. The clerk is the chief financial officer of the county. The clerk has access to every document that he could possibly need to examine or inspect. But he wants to come over to the county and interrogate the county employees by conducting what he calls an audit.
Why doesn't that statute give the clerk the authority to do that?
Because that statute does not give the clerk the ability to come over and interrogate employees because of another statute.
And I'm going to you are now going to, please answer the question. I just want you to be aware you've used up your rebuttal and you're going to use up Mr. Stewart's time. So go ahead.
Chapter 125 gives the board broad home rule powers. And under 125, it gives the board the authority to conduct investigations of county affairs. It gives the board the ability to interrogate county employees. The clerk is not a prosecutor of the county. The county under 125 has been given the duty to prosecute and defend cases for the county, not the clerk. The clerk has no authority to come over to the board and interrogate any employees. This is where we fall apart. As far as the clerk being able to look at any document, they're all public records. As for the clerk being able to look at any account, he has them all. So there's no reason why he can't look at them. He can look at them before payment, after payment, or whenever. But that's not what he wants to do.
All right, well, you're now out of time. I'll give you a minute on rebuttal, but I assume you want Mr. Stewart to have his time. Thank you very much.
May it please the court. My name is Greg Stewart with the law firm of Neighbors, Giblin, Nickerson, representing the Florida Association of Counties.
It seems like we have a real turf war here, and I guess the real life question is this only live in the 20th Circuit, or is this the kind of turf war that's occurring all over the state, and what's really at issue here? Because, we want to make sure that the balance that the Constitution envisioned between the clerk and the board is honored, and not have mission creep. So if you could help us with that.
I think that to characterize this as happening all over the state is not correct.
I said I didn't think it was, but I want to know is this really about politics and a clerk that is just is putting his nose into business that is not his business, or a clerk that is trying to, in earnest, carry out his statutory responsibilities.
Well, and I think that from the Association of Counties perspective, and let me give it that basis, that what we are dealing with is we have various defined roles that the clerk of the court has under the Constitution. He is an auditor for the county. He is the custodian of funds.
What does it mean that he's the auditor of the county?
And good question. In terms of the role that the clerk plays as auditor, it is well defined. And addressing Justice Lewis's question, the Alachua County case, I believe, is still good law, is still viable, notwithstanding the amendment. And in that case, the respective functions as the clerk and an auditor were well defined. He has a pre-expenditure, pre-audit responsibilities. He is to make a determination preliminarily whether a public purpose is served, whether in fact authorization has been made for this expenditure. However, in Alachua and in the statutory framework, post-audit expenditures are not his responsibility. Once that expenditure has been made, then it is the responsibility of a certified accounting firm hired by the board.
How does it come into play that it doesn't seem logical to me that a clerk would have the obligation of making sure that the funds are expended correctly and have some civil and criminal liability if it isn't, when if he cannot go back after he's made this payment and still look at everything to make sure that he in fact made a proper payment.
And I think that this is a problem in defining what he is doing. Nobody is saying that the clerk has no ability to review the records, review the expenditures. However, where the clerk is seeking to now do a post-audit, a post-review, from an audit perspective of these expenditures, he is intruding in another area.
But what does it mean? Again, let's talk about real-life situation. The last part of Ms. Hubbard's statement was he has total access to to examine and inspect all of the funds. So in the scenario Mr. Acriman gives, the clerk can look at the next payment, can look at what happened before. What we're talking about here is, I guess, to try to look at the two discrete issues. Can the clerk, before the payment is made, go and talk to the county department that's requesting the payment and interrogate the employee as to what the purpose of their travel is and what we would consider to be, making sure that there's a legitimate expenditure beforehand? Can the clerk go and talk to whoever he needs to or she needs to about why the payment is being requested?
Pre-expenditure, the clerk has to make a determination as part of his function whether there's a public purpose served, whether in fact.
So what I'm asking you is whether
that type of inquiry I would submit is appropriate.
So they can go from their office over to the board and ask Mr. Smith, are you really going to New York on this, or is there another purpose? And he can ask all those questions.
And that is the function.
Can he do that?
Yes.
And can he also, in terms of looking at one department that kept on requesting payments up to New York, go and find out whether they, within that department, have sufficient internal controls over how their employees are able to travel? Is that part of the pre-audit function?
I would say no. I would say
but isn't that
a post or financial audit done subsequent to the expenditure, whether you have the controls in place. What the framework that we need to keep in mind is what the legislature, how they structured this from an audit perspective. And they have the clerk doing the pre-audit, pre-expenditure. They have an independent entity doing the post. The reason is a check and balance. It's a check and balance not only of county expenditures, but of the clerk. And so that independent third party who comes in, and that provides the transparency for the expenditure. Now, whether in fact the clerk would like to do additional post-expenditure review, he has no statutory authority.
Well, what about 136.08?
The issue concerning the depositories?
And the accounts.
And the accounts.
And I would submit that issue deals with the clerk's role as custodian of county funds.
Well, what about the first part of that where it says the accounts of each and every board and the county accounts of each and every depository?
And I would again submit that that is the role of the clerk as custodian of county funds, and that is granting and clarifying the extent of authority he has as his role of custodian. That is separate and distinct from what we're talking about.
So
on
you
the audit.
view that as pertaining only to bank accounts?
Yes.
That whole section?
Yes. I believe that's what the intent is.
Well, is this whole fight about what you call what the clerk's doing after it's paid? I mean, is that what this fight is? And we're trying to understand this.
This is an issue that it may be definition in Collier County, but it is an issue of significance to the state because in terms of the clerk's role and how he performs that audit function, clarity is needed in terms of how far. Is Alachua County still valid law? Is there a
But again, is it the question of what you call what he's doing? I mean, for example, we know that the clerk cannot do one of these certified audits that you'd call in an external auditor to cover that. We know that, right? But does that in and of itself, after we change the definitions in the statute to refer to financial audits as opposed to an internal audit, doesn't that satisfy and remove the issue that Alachua was deciding on? That is a question that under this statute, who is to conduct these post-payment audits? Is that the sum and substance of this fight?
I think the issue as to who conducts it is clear. It is not the clerk. I think what the issue is in
a financial audit, but the question is, does it prohibit a clerk from doing an internal audit? And we use this phrase, interrogate. I mean, isn't it what Justice Periante said? You go next door and you ask a question. What is this? I mean, and that's, I think we get out of this adversarial rule, which we all fall into too often, that if they can go ask a question about how it was spent. Can't do that.
And I'm not characterizing interrogation. That's not my role.
Well, that seems to be thrown around. So.
I understand. What we're dealing with, though, in terms of this, and I think it's important from the Alachua perspective, is you asked a question concerning the change in statutory law.
Right.
The function of this post-audit that was addressed in Alachua, as opposed to financial audit, has not changed. It still requires a review of expenditures to determine their legality. The change that has occurred because of that is that the legislature now requires, in addition to that, an opinion that the financial statements meet the general accounting principles. It requires more than used to when Alachua. But in terms of a review of a post-expenditure analysis, that in fact is the responsibility of an independent third party to operate.
Well, I don't think that's the question. The question is, does it preclude one of these internal things for a clerk to ask about the expenditure, not to do a financial audit, but as Justice Polston has asked, is that it's talking about accounts, responsible for those, and to do it on an internal basis.
Well, let's put some definition to the term internal.
And as you're answering, you're now 5 minutes over your time, but I think this is important enough, and you're giving some additional insight. We realize we took the case because it has some important implications, so please answer the question fully.
I apologize.
No,
I'm not trying to use your time.
No, it's already gone. It's over. I just want to make sure. I don't want my colleagues to be upset that we're unduly extending the time. So please answer these questions. I think it's important.
Assuming that we use an internal audit or internal review, and it constitutes going to expenditures that have already been approved, and to determine subsequent to them that they are illegal or legal, that is beyond the authority of the clerk. That is the responsibility of this independent accounting firm. And so that is really what we're dealing with here, is we're basically going after the expenditure of these funds and making a subsequent analysis. Now,
well, I mean, would a clerk, let me just ask one question. Would a clerk, if I'm working in that position and that you, working with the county, have made a representation to me for reimbursement for whatever it is, XYZ, and I'm responsible for that, and somehow there's a miscommunication initially in the approval, whatever, and not to get involved in calling in the cops and all that stuff, but to determine the flow of county dollars. Can I, as a clerk, go see, I'm going to as Justice Perry, I'm going to New York and here's our expenses, and then all of a sudden it comes back and there's some funny expenses there. Money's already been spent. Can a clerk look at that and ask, what is that?
Well, it may seem that it is overly restrictive to say no. But that is
That's
the way
the
that
answer.
we are structured in terms
Okay.
of that the clerk has a very limited.
They can, in that situation, they can go, who would they go to? The board to say, I need to ask additional questions?
That would be one, or they could go certainly to the outside auditor, the post-expenditure. That's why we have that independent person who's making an independent review that whether the clerk should not have approved a prior expenditure.
Okay, now where does it say that they cannot do that?
It does not say specifically,
Okay.
but
All right.
the clerk being has no authority except that which has been expressly granted to
Or
him.
implied to carry out the terms. I mean, there's
Well,
a long list of.
and I agree
The
that-
question is, should it be implied here?
I would say no, because what you're dealing with here is you're implying that he has an authority that has been legislatively granted to a specific individual, and it ignores the checks and balances that the legislature has attempted to build into this process.
Thank you very much for your assistance. Time, again, is completely used up, but I'll give a 30-minute rebuttal. And Mr. Acriman, you're up.
Good morning. May it please the court. I'm David Acriman for the Clerk of Collier County. The second DCA correctly analyzed the 4 statutes which implement the 2 articles of the Constitution which define the clerk's constitutional roles. And the court held that the clerk's practice of performing internal audits was a reasonably implied power in order to carry out his very important
What is
duties.
it? Let's sort of trying to understand what it is. It appeared to be that that this came out of something where the clerk finds out there's some other fund that was for the fire department and wanted to get into what this other fund was, and that the underlying tension is it appears that maybe there was a political, it may have been done for political purposes. So how to, without hamstringing the clerk and what is legitimately there a requirement, why isn't what Judge Silberman and the trial judge said a better policy? And if the legislature feels that the clerk should have additional responsibilities, let the legislature be clear about it.
Well, what Judge Silberman concluded was there are a number of powers given to the board which overlap. The powers given to the board in Chapter 125 do include these powers of investigation, powers to interrogate, whatever you want to call it. But what was wrong about the dissent was those should not be interpreted in a way which supplant the constitutional role of the clerk.
Except that you got a functioning board separately elected with all these employees. We've got a separately elected clerk of court that has a separate office. And there is something about, again, where we've, in many cases, have defined the clerk's role as essentially ministerial. So the idea of the clerk becoming an investigative arm to look into things that that the county is not looking into, because all they have to do is say to the county, listen, there's something going on, and which is they apparently did, and the county got the money into the clerk. So what my concern is that it becomes political, where you have another independently elected officer who has a lot of other responsibilities, certainly with the court records, coming in and exceeding or overlapping with authority granted to the board when that authority hasn't been expressly granted by the legislature to them.
Well, a couple things. Chronologically, what happened here was the clerk learned that a fire district was keeping this non-governmental account, that checks made payable to the county were being deposited in this account. He also found an account where a fire district called upon the county to impose a fee for a developer to buy a fireboat in order to go out to the island of Capri. Instead of that money going to buy a fireboat, it was deposited in this account, and the county used taxpayer funds to buy the boat. After the clerk learned about that, he filed a declaratory judgment action asking to have the money returned to the county and to be able to perform an accounting. The account had been maintained for years, and he wanted to make sure he was able to account for that. That's where the political problem arose, because the county.
This account, though, as I understood it, this account actually had monies that the firefighters themselves had put into this account. Is that correct? And would that be county funds?
No, the money that we were concerned about was
But but there was some other monies put in there.
a check
Is
made
that-
payable to the county was deposited in a non-governmental account.
Well, Miss, this is not a.
So
you can't
after the
just
clerk
speak out.
after the clerk filed suit, the county responded by filing this quo warranto action, which seeks a judgment of
Does
ouster.
the clerk has authority and is the collector of fees in its court-related function, but do they have any authority to collect funds for the county, or they delegated any responsibility in that regard with respect to county funds? Or I guess I thought
No.
they do not have that authority.
And that's not in our record. That's not a problem in our record. We don't have a situation where the clerk is saying, he maintains the accounts, he's the custodian of all county funds, and I guess there's some circumstances where he collects fees.
But in other words, that's outside of, the bottom line on that one is if there is some other misconduct going on, he can report, I guess he could go to the press, he can report it to the auditor, the independent auditor. He can look at, like any citizen can, look at the public funds. But the question is whether he or she, generically the clerk, can then start to do additional investigation about something that was not placed in one of the depositories. And that's, I don't see where they have that authority.
Well, it is the implied authority. Well, there are a couple things we're talking about. If we're talking about the fire district case, let's look at our record. What the clerk did was he called that problem to the attention of the board, and the board required them to return it. That seems to me to be a reasonable thing to do.
A question in terms of the clerk's authority with respect to the board. We're very familiar with the clerk's authority reference to the court records.
And that's very different.
We're so happy that we're here on something other than that kind of dispute.
And
but,
I need to
but
emphasize
what is
that.
the idea that the clerk was made an auditor for county funds in terms of the separation of power? It looks like Mr. Brock is asserting that somehow that then gave or should give the clerk some greater responsibility for ensuring that the financial status and how things are going within the county should be his responsibility. No,
I disagree.
That's not what this is about.
Correct. If you take Alachua County, this court's decision in Alachua County, and you substitute the words post-audit with the words financial audit or external audit, and you take the words pre-audit and you substitute the words internal audit, that case is alive and well today. It's a pretty traditional organizational setup. For example, in a public corporation, you have an internal audit department which is away from marketing, sales, and procurement, and they periodically conduct internal audits. When the external auditor comes in on an annual basis, that external auditor is doing a financial audit and is rendering an opinion on the fairness with which the financial statements are presented. Those are different functions, and the clerk's internal audits, it's a pretty mundane, routine event. If you look at the county's appendix, where all these internal audits are, what happens is someone will say to the county, for example, would you show us the policy which governs your purchases? Would you show us the contract by which you're making these payments or asking us to make payments? And let's look at a period. Let's test a period of this 6 months to see what your controls are like. So, for example, in a Parks and Recs audit, county employees have credit cards, and one employee was violating the policy against limits by breaking up the purchases, much like that Escambia County judge did in the Mays against Flowers case. So the clerk found that he had made payments because a county employee misrepresented the payments.
So what is it we're really arguing here about? The more I hear of this, the more I am not sure what is it that the clerks say they have the authority to do that the board says they don't have the authority to do.
The clerk would like to continue the practice of conducting internal audits in order to...
Now, what do you mean when you say an internal audit?
An internal audit is where you ask for papers and you ask questions of employees. And that's perfectly reasonable for someone.
Pre and post, is that what you're talking about?
Not related to the date of the transaction. There is some due diligence which occurs before a payment's made, but you simply cannot do it all. They make payroll every 2 weeks. You can't count every
And isn't really the dispute then is whether the Constitution and the legislature intended what sounds like a much broader authority. We're talking, you say there's implied authority, but to me, it seems like it would be far better for there to be a statutory grant of this explicit power because it is intrusive. I mean, it's not, it may be innocuous, but it's intrusive. I mean, we have, I don't know what we call him, an inspector general, and he's within the court system. You know, the thought that, that it just makes sure that things are going appropriately within the court system. And the idea that there's somebody else that is separately elected and accountable that the board has nothing to do with, that comes in and just, again, maybe in all the other 66 counties, they have this perfectly wonderful working relationship, and this occurs and nobody ever brings it to attention. But that the overreaching is, where is it stated that that's within their authority? And I think that's what we're getting back to, is that it may be not misused, it may be a good purpose, but is it one of the powers that they've been given?
It is one of the oldest powers that the clerk has held in the state of Florida. It's been in the Constitution forever, and it provides a check and balance.
Which just means that, so you would say that auditor itself, even though it says, and any obligations are those that will be set by law, by the nature of what an auditor is, gives the clerk broad powers with reference to investigation of county activities with respect to the finances?
Two things. The two constitutional provisions brought to life by the 4 statutory provisions cited by the second give the clerk the power we're talking about. And I would disagree. It's not intrusive. You can look at our record. It's perfectly reasonable for a county employee who's responsible for expending county funds to be responsible to answer questions.
As what? As part of the audit?
As part of an internal audit.
And you have a constitutional power, your client, as auditor.
Yes.
Okay, so then the question is, do we interpret auditor to have limitations?
Sure.
That's what this case is about.
Well, the limitations are, we don't have a case where a clerk has pushed or acted arbitrarily unreasonably. If our fact pattern, for example, showed the clerk using an internal audit as a subterfuge to defeat legislation, and there are some cases where clerk, that's not our record. Our record shows perfectly reasonable, normal, routine, traditional internal auditing, and the county can't show you an internal audit where the clerk abused that power. I mean, I've read all 67.
So would you, just one more time, explain to me, when you say an internal audit, what does the clerk actually do to perform an internal audit?
I'll give you an example. The clerk will write a letter to the county department and ask for whatever governing document controls their purchases, whether it be a contract with a vendor.
And this is in response to a request for the clerk to pay something?
No, this is just to test the internal controls, to assess the risk, because down the line the clerk is going to get requests from that department for payments. They want to see what their internal controls are like.
But can't they do that? I mean, if the next time there comes a payment, no one's arguing they couldn't ask about, I don't know, but about the internal controls at that time. Or is that maybe that is in dispute, whether they can do it in relationship to a payment, but not after a payment's been made?
I don't think the county disputes. Well, that's the funny thing about the county's argument, is they have no problem with any inquiry done before payment, but a monitoring of internal controls is always going to be before some payment. So it is a little bit of a semantic difference.
It seems to me that 136.08 gives the clerks express authority to conduct internal audits. Would you agree with that?
I think so. And it's not a stretch to say you're allowed to ask someone a question about the records. You have an entitlement to review under the language of the statute at any time. That seems to me that express language is more powerful than the prefix pre-audit in this court's decision back when post-audit was a defined term in our statute.
But does that section say that that the clerks have the right to inspect and examine accounts.
Yes?
That's what that
Yes.
section actually says.
And accounts are defined 3 subsections before that in 13605, which deals with, it says, a complete set of books showing the amount on hand, amount received, amount expended. So that would necessarily mean money spent.
Is this the, well, I'm sorry, go ahead.
Do you have your?
Is this the typical kind of situation, or maybe not typical, the kind of situation that would be discovered on a post-payment audit was one such you're talking about?
Sure.
with the credit card, and you approve the expenditures, but now what they're doing is to subvert what the requirements are. They're splitting them up and still paying it, and they ought not do that.
Yes, this is perfectly.
That's kind of example.
I mean, affirming the second DCA is a powerful affirmation of the principles of transparency in government, responsible accounting. We're not talking about this is a very modern, complex financial organization, and internal audits, there's no dispute about that. If you look at the accountant, even the accountant for the county said internal audits are a reasonable way to monitor internal controls, and those are important for the work which we do, to make sure the financial...
Does the board conduct internal audits?
The board may, it has. I mean, for example...
Well, is that within their authority? I mean, does
Sure.
the board have that authority? So you're saying this is something that the Constitution, the legislature, intended to give duly to two separate...
Correct.
And that's intended to, what, keep the board honest?
Yes, that's what this court held in Alachua County.
And does the board have the same duty, obligation to look at the clerks?
No.
No.
I mean, in Alachua County, the legislation which this court held unconstitutional was one where the legislator said the county will be the custodian of all funds. And this court held that's unconstitutional because that supplants the role of the court. So there can be duplicative powers. This court held that in Alachua County. What would be wrong is, that, as the dissent suggested, is because all these powers reside with the board, the clerk's role there is supplanted.
Does anyone audit the clerk's office?
Sure.
Who?
Some of the audits that are in the county's appendix are internal audits in the clerk's own department. It's again.
So the clerks audit themselves?
Sure. When
And
they're
who
collecting,
else can audit the clerks?
well, they audit themselves. They're internal.
Can they have a
audit.
financial audit, an outside auditor come in?
Yes, when they report, they're also subject to the external audit.
External
which
audit.
happens on
Does
an
the
annual
Auditor General audit the clerk's office?
I don't know. I do know that when the clerk reports on its finances and operations, and that's audited by.
Well, that's a separate issue. But I guess going back to, and I have to go back to the statutes. Is this a case of express authority because the statute has given the clerk the authority to conduct internal audits rather than implied authority? Because I keep on hearing two different versions.
This court has held, and the second DCA was faithful to this court's holding, that you can imply powers necessary to make effectual and complete express powers. There are 4 statutes giving the clerk express powers, responsibilities with onerous liability.
But none of them specifically deal with this type of situation, whereas the legislature gave the board specific authority in that area.
I will acknowledge that the legislature's articulation of the powers of the board are more modern and therefore more detailed. But if you put those 4 statutes together, as Justice Polston has told us, the clerk has the right to inspect the books and expenditures.
I mean,
at
is there
any
an
time.
ambiguity here? Because I guess, in my view, and it may be not the majority's view, it would be, given the political nature of the situation of of elected officials, that would really be better for this to be aired before the legislature as to whether the clerk's authority in this, in the area of auditing is plenary or it's restricted. But that's just
I
my...
would disagree with that. The legislature cannot pass a statute which supplants a constitutional role.
But you would say then that just by being the auditor, They have expansive authority. And
Now,
I
by
thought,
being the auditor who's responsible for payments personally, I mean, there's no other constitutional officer I can think of who's personally responsible for unlawful payments, and who can
that's
be...
not in the
That's not
Constitution.
necessarily.
That's in the statute brought to life, but that's in 12909.
But is that necessarily a power of an auditor? That's a power that was actually given to them under the statute.
Yes, yes.
It's
That
not
is-
inherent in being an auditor.
I would suppose that's true. But an auditor who can't audit is not, I mean, we should give life to these provisions in the Constitution in today's factual setting.
Justice Parente keeps going back to the issue as to, and I think we've asked the county about, the nature of this, and this is a fire board and stuff. Is this some kind of political dispute going? We haven't asked you that, because that's the kind of thing that the courts ought not be involved in, is this, petty political bickering, and we got to try to get it right. Is that the only reason this case has come up here?
I don't see it that way. I'm defending a summary judgment in the quo warranto complaint sought an ouster of the clerk from performing these obligations. These are crucial obligations for him to
Okay,
carry
I
out.
see that, but is that because, is there something underlying all this fire board stuff and all that going on?
I don't know.
I've seen language talking about the clerk being a watchdog.
Yes.
Now, is not the clerk's function to, before they sign a warrant, they have the right to do whatever they need to do to make sure that it's proper?
Yes.
After the warrant is signed and written to them, do they have authority then to go to the person who received the warrant to talk with them, inspect with them after the fact? Or is that the function, or should they just notify the county that there might be a problem, or should they notify the state attorney there might be a problem, or should they notify the Auditor General that there might be a problem, instead of them doing it? Because I can see this having political ramifications, and this whole thing is really about politics. And we would try to make a decision based on the law, but then it would have statewide ramifications, because the clerk is very jealous of his power, and of course the county is too, and they should be. And in my opinion, if we shouldn't imply anything from a statute that the legislature didn't put in it, because they can do it. They can do it next session if they wanted to.
Well, a couple of things.
And in answering, you're now out of your time, but since we gave the other side time, please answer Justice Perry's
To answer the questions on the political issue, if we had a record, if there was evidence in the record of some kind of political abuse or motive, for example, if the clerk was trying to use this internal audit power to thwart legislative decisions, I could certainly understand that concern. That's not in our record. As far as your question about the pre-audit function, again, that term pre-audit was never, as it's defined by this court, it doesn't have any time horizon. It says pre-audit meant the legality of the payment. Legality of payment means, was it budgeted? Is it in compliance with law, competitive bidding laws, for example? That's what that means. That simply cannot be done all before the payment's made.
Can the clerk be an investigator after the fact? I mean, they can look at the documents, sure, they look at the counts, sure, but can they go beyond what is already in their possession in order to do the investigation? Or do you think they should be able to do things other than to audit their accounts?
The clerk's not looking to be a prosecutor. He's not looking to issue subpoenas. He's looking to, the work he's doing is reasonably and directly related to the roles he's talking about. We don't have a record where he's calling in witnesses or creating a chamber or issuing subpoenas.
So you're saying he can't do it?
He's asking questions.
Can he do that? Or
Sure.
should he be allowed to do it?
Yes.
After the fact? You can
After
call
the
him in
fact.
and ask questions?
Yes.
Okay.
All right, thank you, Mr.
Thank you very
Acriman.
much.
And with that, you're out of time. 1 minute, and that's it.
I simply want to remind the court that it's true, but under White v. Crandon, which is a 1934 case signed by this court, which is still good law, an express power duly conferred may include implied authority to use means necessary to make the express power effective, but such implied authority may not warrant the exercise of a substantive power not conferred. Finally,
Well, let me ask you a question. I mean, an audit, is it your view that an audit can never look to see how a payment's made?
I think that the clerk has the statutory and constitutional power to look at how a payment is made or is going to be made before he agrees to sign the check.
We can't look at how it was made before it's signed. The question was, does an audit include the concept of looking at something after it has been paid?
The audit.
An audit.
An audit would include looking at something before and after. The clerk does not have that power, has never been conferred that power. And before I leave, I just want to say one thing. The legislature spoke on this issue and devised an entire scheme under Chapter 11 that totally excluded the clerk. And one of the reasons the clerk is excluded is because the clerk cannot audit himself. The clerk is a part of Collier County government to the extent that he is the financial officer. Before any check is cut, all manner of information is conveyed to the clerk.
Thank you, Ms. Hubbard.
Okay,
All
and
right.
then after that check is cut, his duties are over.
We know this is an important issue, and we appreciate the attention everybody has given it and the arguments here today. The court will be in recess. Thank you.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU TV, and Florida State University.